What?
Reporter, he wrote was like, hey, let's take breaks at a certain time.
Oh, okay. No, I didn't see that yet.
And I think the reason he did that is because Elizabeth went last time kind of very long.
Oh.
I think,
Okay. So,
break as much as he wants. That's the game.
yeah, I mean, why don't we just ask him to set it?
Whenever you want, I thought I told him in the email, I said, dude, whenever you want, like, he said, you go for an hour and a half and take a break. You do another hour and a half and do a break. I was like, you need more than that. I don't want to go long either. I drink a lot.
Right.
But
It's true. We're all sitting here way too long.
Oh.
Hello, Mr. Lee. How are you?
Good, Mr. Ryan. How are you today?
Fine, thank you. Audio sounds great.
Thank you, sir. Yeah, yours does too.
Terrific. Okay, see you in a bit.
You bet. Good morning, Mr. Albert.
Good morning, sir. How are you?
Good.
In a while.
Yes,
Is
sir.
Is the audio okay there, David?
Yes, sir. Ms.
Great.
Gould, can you say something so I can hear your audio?
Sure. Let me see. I don't have it on mute, so it should
No,
work.
you're good. I can hear you.
Okay.
How's mine?
You're good, Ms. Gould.
Great, thank you.
Can you hear me as well?
Yes, sir, Mr. Borman.
Thank you.
Yeah, sounds good, Brett. I'm going to go ahead and put mine on mute for right now.
Good morning, Mr. Lee. Do you hear me?
Yes, Judge.
Thank you.
Good morning. Yes, we'll do a sound check here as well. Can you hear us okay?
Yes, sir. Can I get your name?
Sure. Dan is the first name and Aikenhead is the last name.
Thank you. And with you, is that Ms. Kelly?
Samantha Kelly, correct.
Thank you, ma'am.
Great. Thank you all.
We'll start in about a minute. Okay, it's 9 a.m. I'm hearing an echo. Is everyone using headphones? Oh, there, the echo's gone. For those of us joining on Zoom, maybe perhaps for the first time, one of the things that's really essential to understand about Zoom, Mr. Lee, we don't need to have this on the record. I just want to say this to folks. Your speakers, if you have an integrated speaker and microphone in your laptop or in your desktop setup, whatever, any noise that comes out of your speakers will then flow back into the microphone that you have, which is why Zoom, when we had a meeting with them way when the pandemic first started, said to us, you must wear headphones. So I don't really particularly like looking like an air traffic controller, but it is absolutely essential to use headphones and a quality mic on Zoom. And as for the quality mics, the other thing I will tell you, every single laptop and desktop PC, if you have a built-in microphone, it's a piece of garbage. It's the worst microphone that money can buy. Why? Because they design these machines to be as cheap as possible. So, the other thing is, and if you watch open meetings, which I know all of you do, you will see instances where folks are coming to the commission and they're talking and the audio is terrible. And it's very frustrating. And Commissioner Hall often has to ask them to repeat stuff, and that's not on her, that's legitimate. So we want to be able to hear what you're saying. Everyone wants to hear what you have to say. So go buy your air traffic controller setup and join the hipsters. All right. So Mr. Lee, are we ready to go on the record?
Yes, sir.
Terrific. Okay, we are here for a hearing in case number 22-00143 UT. Today is Thursday, September 8th, 2022. My name is Christopher Ryan. I was appointed as a hearing examiner to preside over this case. With me today is Miss Angelica Anaya Allen, co-hearing examiner here. Miss Anaya Allen, introduce yourself for the record.
Angelica Anaya Allen. I was appointed as a co-hearing examiner in this matter by the Public Regulation Commission.
Thank you. And I also just use these appearances and just introducing everybody to do the sound check, which we already did, but we can make sure it works. All right, so let's do appearances. P&M.
Good morning, hearing examiner Ryan. This is Dan Aikenhead, outside counsel, appearing on behalf of P&M, and with me is Samantha Kelly. And Stacy Goodwin will also be appearing via Zoom, but Sam and I will be the ones interfacing with you all.
Terrific.
Good morning, Mr. Hearing Examiner. This is Stacy Goodwin. I'm actually going to jump off the Zoom so that you don't have your screen cluttered up. I really just wanted to let you know that Leslie Padilla, who is the managing in-house counsel for this case, is out on leave, and we don't expect her back until next week. So I wanted to let you know that her absence is unavoidable. So thank you very much, and I'll go ahead and jump off.
Thank you, Ms.
Need me,
Goodwin.
I'll be around.
Appreciate it. Thank you. Okay, the first intervener in this case was NEE. I know Ms. Nanasi, Marielle Nanasi, filed a motion yesterday saying she would not attend. I don't see her here, so I assume that she will not be joining us. New Mexico area.
Good morning. I put headphones on. Is my sound still okay?
It's very good. Yeah.
Okay,
Yeah.
great. My name is Kelly Gould. I represent New Mexico Affordable Reliable Energy Alliance, also known as NM area. Thank you.
Thank you very much. Do we have someone from the Attorney General with us? They also filed a motion indicating they may not appear, and I don't see them as a participant in the participant list here, so I assume we may not have them. That's fine. CCAE, the Coalition for what is CCAE again? Citizens for the Coalition for Clean and Affordable Energy. I never can keep that straight. Ms. Lynch intervened in this case for CCAE, but she is also not here. Oh, there she is. Thank you.
I'm here. Good morning, Kara. Good morning, Kara Lynch with Coalition for Clean Affordable Energy, otherwise known as CCAE. We advocate on behalf of low-income New Mexicans as well as all New Mexicans for clean energy.
I always want to replace coalition with citizens. Those are close kind of cousins, I guess, but in any case. Thank you, Ms. Lynch. Yeah. Bernalillo County, Mr. Albright.
Yes, good morning, Mr. Hearing Examiner, Madam Hearing Examiner. Jeffrey Albright with J. Albright Law LLC here on behalf of Bernalillo County. And again, we had filed a motion to periodically be excused. I may participate in some, but we have waived cross-examination and just wanted to reserve the right for to file and participate in post-hearing briefs and so forth. But I don't expect to be very active in the actual proceeding.
Very good. Thank you, Mr. Albright. And, just to address that too, it's fine. I understand people are very busy. That's no problem. I think from our perspective as the hearing examiners, I mean, if someone has intervened and then declines to come to hearing, it sort of seems like, well, you must not have thought it's that important. But I understand ultimately, like, folks have other things to do. And I appreciate you filing the motion, and it's totally understandable. So thank you.
And thank you. And obviously, if I am absent, we certainly agree to abide by all the orders and or bench requests that may be issued from the bench and waive any right to object or to appeal.
Appreciate it. Thank you very much.
Thank you.
Mr. Borman.
Good morning, Mr. Hearing Examiner and Hearing Examiner Allen. My name is Brad Borman, appearing on behalf of Utility Division staff. I am joined by my co-counsel, Joan Ellis. And Joan, you can say hello if you like.
Hello.
Okay, so we know your audio works. That's great.
Yes.
I am also joined by our two witnesses, Bamadou Otara and Mark Tupler.
Thank you, Mr. Borman. And I see Mr. Herman as well. How are you, sir?
Doing well, Mr. Examiner. Thank you. Keith Herman on behalf of the Albuquerque-Bernalillo County Water Utility Authority. And we had not filed a written motion, but I would like to move now that we may have also periodic absences and requests to be excused, and acknowledge we'll be bound by any determination by the hearing examiner and waive any cross-examination in our absence.
Thank you very much, Mr. Herman. That's fine.
Also, at some time, we may also be represented by co-counsel Dal Harris.
Terrific. Okay, so that I believe is everyone. Did I miss anyone? No. Okay. As of 8:41 a.m. this morning, Thursday, September 8th, 2022, the paralegal for the hearing examiners, Ms. Anna Kippenbrock, reports no one has contacted her to make public comment. There was no public comment filed on eDocket, so we can move on beyond that. Are there any motions or preliminary matter before we move to the evidentiary portion of today's proceeding?
Mr. Hearing Examiner, PNM does have a few preliminary matters we'd like to address before the evidentiary portion, but no motions. I'm not sure if anyone else wants to speak to that point before we go into those preliminary matters, but we do have a few.
Okay. Well, I don't hear anyone chiming in to do anything, so go ahead, Mr. Aikenhead.
Great, thank you. First preliminary matter has to do with the exhibits that PNM uploaded into Dropbox yesterday. There are a number of documents that were uploaded that we do not plan to introduce into evidence through our witnesses. And we wanted to address that issue with you up front to see if you would like us to renumber and resubmit the exhibits we intend to introduce into evidence, or if you would like us just to simply use the pre-numbered documents that have already been uploaded into Dropbox.
Is this PNM Exhibit 13?
There are a number of them. Yes, the intention really is to only introduce into evidence the direct testimony of PNM witnesses, the rebuttal testimony of Mr. Phillips. But with regard to the other documents, and namely the responses to the bench requests, we didn't intend to introduce those into evidence through our witnesses. We understand that you may wish to attach those as commission exhibits, which is fine, but we didn't intend to introduce those through our own witnesses. So we can renumber and resubmit, or just simply use the exhibit numbers we have. They may just be slightly out of order. So we wanted to make sure we handled that right away.
Okay, so if I understand correctly, what you're indicating is PNM exhibits, I mean, you can tell me if I'm wrong or correct, whatever, 4, 6, 8, 10, and 12, you don't intend to admit those?
That is correct. And also PNM Exhibit 13 and Exhibit number 1, which is the application, we wouldn't be admitting that. We just move to admit the direct and rebuttal testimony.
Yeah, I mean, I understand. I mean, is the idea with the application that you should treat that as a pleading?
Yes, sir.
Yeah, I mean, that's I understand that. So I don't want to, let's say, well, I understand the question you're asking. I think the simplest thing would be to for purposes of, for the court reporter and for the record, would be to not mess with numbering. And then I will simply admit the bench requests as commission exhibits, 1, 2, 3, and so on. And I think what I will do is, since the responses are relevant to a particular witness, I'll just introduce those at the time that particular witness is presenting as commission exhibits. Does that work for you, Mr. Aikenhead?
Understood. Yes, I think that makes sense. We'll just stick with the same numbering and allow you to introduce the supplemental testimony as commission exhibits.
Yeah, and so to the extent to which we jump around in the direct testimonies, because there's those, your PNM's exhibits won't include like in between numbers. I think
Correct.
You'll only have the odd numbers. Actually, is how that'll sort of work out ultimately.
Right. Thank you for that. Apologies for the confusion, but I think that way should be just fine.
That's fine. And can I just ask, is it PNM's position that It's not obligated to admit as evidence questions the hearing examiners want answered, and that's the commission's obligation to admit those documents. Is that the basic position you're taking here?
From our perspective, and keep in mind, Sam and I, we've only been involved in a number of the dockets. Our understanding is that traditionally that is how PNM approaches those types of exhibits in these matters. So what we've done is just try to maintain some sort of consistency with what PNM has done in the past on that.
Yeah. You're not, however, taking the position that the responses to any of those questions in terms of the accuracy of what is said by the witnesses should be doubted, that you don't want to admit them as your own exhibits.
That's a fair statement. I would agree with you, Mr. Hearing Examiner. There's no, we wouldn't want to read into it that far. No concern about accuracy of the statements made in response to the bench request.
Yeah, and it's interesting because, you know, as the hearing examiners and presiding officers, right? So we're not engaged in cross-examination of witnesses. It is an examination, and the answers to that examination are slightly different than, say, the answers given to, just to use the example of Exhibit 13 and the varying interrogatories and responses to Ms. Nanassi's questions. I mean, that takes on, I think, for purposes of litigation, a slightly different. I mean, you can still object to the commission's questions, I suppose, and I've had that occur in cases. But in any case, we don't need to go further on that. That's fine. Is there any comment from any other party on this subject?
I have a comment. This is Kelly Gould.
Yes.
I guess it's a question. How would you like me to handle Mr. Meyer's response to the bench requests?
My preference would be to just admit them as exhibits of New Mexico area. Okay. It's your witness offering responses, obviously, to my questions, or to our questions, Ms. Anaya Allen's and I's. But yeah, I mean, this is a discussion I'll have with the other hearing examiners about what the preference is. But my preference at the moment would be for Mr. Meyer to offer those as NM area exhibits.
Okay, that was my plan. I just don't know if that would be confusing if half of the answers to the bench request are commission exhibits. Okay.
No, I think the question about can PNM exercise or any utility, right? Could any party say, I object to answering that question and you can't force me to admit evidence? That's an interesting question. I think probably actually the commission can, but I don't need to answer that today. So I'm happy to admit those things as commission exhibits. They come in, it's sworn testimony. I think a utility can make those arguments, and that's legitimate. So I think they lose them, but in any case, we don't need to get into that. But I'm fine, Miss. I think it'll be fine and perfectly clear on the record, given the discussion we're having right now, why this has happened the way it has.
Okay, thank you.
Thanks, Ms. Gould. Anything further?
We wanted also to address the order of witnesses up front.
Sure.
One of our witnesses, Ms. Andrea Sanchez, has some limited availability during these 2 days. We wanted to make sure and make a request that she could testify first today. I know that we traditionally in these proceedings have our policy expert, Mr. Phillips, testify first. But we just wanted to address that as a preliminary matter to make sure we could discuss that issue and make sure everybody was okay with that before we proceeded with that order.
So I can say from my perspective, I don't see there being a significant problem of any kind with Ms. Sanchez proceeding first to give evidence if she has scheduling conflicts. Do any of the parties present have any objection to that?
No objection. I think PNM has a right to order its witnesses as it sees fit.
Yeah, that's fine. I don't mind. I mean, it's sort of, I think oftentimes just for purposes of coherence, it's easier to have the witness presenting kind of the macro picture, and then from there to have incrementally the witnesses supplying specific aspects of a particular case, second, right? Just from a kind of comprehension perspective, but scheduling conflicts frequently dictate a different outcome. So that's fine. We can have Ms. Sanchez first.
Thank you all. Yeah, that all makes sense. And lastly, we have not addressed, and sometimes we do in these proceedings, any specific time limitations on cross. I just throw that out there as an issue that we might want to consider. But that's the last of the preliminary matters from us.
Yeah, I don't see, we have a 2-day hearing here. My anticipation is this proceeding is going to move along rather rapidly. I've asked the questions I need answered in bench requests. Everyone's very familiar with the larger global issues, the 2025 timeline, delayed, project completions. That stuff is the big picture, and we're not really here to have extensive discussion about that, though it certainly sort of frames all of the thoughts, right? So I don't think we're going to use all the time, and I'm sure we'll finish up today, and there'll be no need. And then in terms of order of cross-examination of witnesses, my feeling is to utilize the order of intervention. So we would just, P&M will present. Ms. Nanasi would go first if she were here, but she'll not be attending. Then it would go to NM Area, the Attorney General, who also is not here, and then to Bernalillo County Water Authority, CCAE, Bernalillo County, and finally staff. Is that acceptable to everyone?
Yeah.
So heads are nodding. Yeah, I understand. Okay. Anything further?
Nothing further from P&M. Thank you.
And I don't hear anything else from any other parties. So let's proceed to the evidentiary portion of this proceeding. And P&M, you may call your first witness, who will be Andrea Sanchez.
Thank you. If you wouldn't just give us 1 or 2 minutes to make sure that Andrea is set up.
Sure, no problem.
We will call her first.
Good morning.
Morning, Ms. Sanchez.
Good morning, Mr. Ryan.
Ms. Sanchez, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Good morning, Ms. Sanchez. Could you please state your full name for the record and your position at P&M?
Andrea Sanchez. I am the manager for the Customer Interconnection Department at P&M.
And have you pre-filed testimony in this case?
Yes, I have.
Do you have a copy of what has been marked as P&M Exhibit 7 in front of you?
Yes, I do.
Can you identify what that is?
It is my direct testimony.
Was this testimony prepared by you or at your direction?
Yes, it was.
And do you have any corrections to make to your direct testimony at this time?
There was an error that was identified in the direct testimony that was clarified and corrected in the bench request.
Okay. And if I were to ask you the same questions in your direct testimony today, would your answers be the same?
Yes, they would.
Is your direct testimony true and correct to the best of your knowledge?
Yes, it is.
And with this, P&M moves for the admission of P&M Exhibit 7.
Any objections?
No objection.
Don't hear any, so P&M Exhibit 7 will be admitted.
And at this point, P&M passes the witness for cross-examination.
So this is the only curious part about the procedure of having the commission admit the exhibit. So Ms. Sanchez, correctly indicated just a moment ago that there was an error, and I was happy that she pointed that out in her supplemental testimony because it actually answered a significant question, which was, her assertions weren't supported by the evidence she submitted. But when that changed and we knew that the price was actually $150 and not $100, that sort of answered all that. But P&M not admitting it as their own exhibit is sort of like, we don't want to admit our own corrections that are necessary. So, I think the bench requests themselves are not intended to sort of be a provocative document. It's meant to be like, hey, I'm trying to understand what you're saying. So in any event, I'm going to go ahead and admit at this juncture Ms. Sanchez's supplemental testimony in response to bench requests of August 23rd, 2022. That supplemental testimony included an exhibit. It was PNM Exhibit AS-3, which was the corrected chart. And I will ask Ms. Sanchez. Ms. Sanchez, you're familiar with the responses you gave to my questions, correct?
Yes, I am.
And that testimony is true and correct, is it not?
Yes, it is.
And if your counsel were to have you sit here today and offer this testimony as if you were presenting it in a live format, would you give the same answers if asked these questions today?
Yes, I would.
Very good, Ms. Sanchez. For the record, Ms. Sanchez's supplemental testimony in response to bench request of August 23rd, 2022 will be admitted as Commission Exhibit number 1. Are there any objections to that?
No.
Hearing none. Commission 1. All right. So, good. Ms. Gould, do you have any questions for Ms. Sanchez?
No questions.
Mr. Herman? Is she still with us or no?
I am, Mr. Examiner, and I do not have any questions, and I'll let you know in advance if I have any questions for the examiner, so you don't need to call on me.
Great. Ms. Lynch?
Right now, I have no questions.
Mr. Albright?
No questions, Your Honor.
Staff?
I have no questions for this witness.
Very good. Let me see just a moment. This is, since we have Ms. Sanchez here, I suppose this is not so much a question for Ms. Sanchez as it is for PNM's counsel. There were some attachments to the bench request that I issued, and I asked if these are documents to which PNM would object to the admission of. You know, so when I sat down and started to try to think through what was all the thoughts that one needed to have when you're talking about abandoning these rec purchase programs, you know, you really have to have some context to understand fully what the consequences of that is. And, you know, I was happy to see Ms. Sanchez agree with most of my bench request questions, saying, yes, that's grounds for, you know, allowing these programs to lapse or to terminate, whichever word you want to use. So I don't think I need to admit those attachments as exhibits in this proceeding. I can take administrative notice of those documents. Does PNM object to that?
No, we would have no objection to their admission as either exhibits or as commission exhibits, however you like it.
Yeah, or just taking administrative notice of the document as it existed in another case. Generally, you know, that I'm cognizant of the fact that, you know, admitting something that wasn't admitted at another hearing could be an issue, but certainly when something's admitted subject to cross-examination in an earlier case, it's hard to argue, well, you know, the facts may change slightly and we have to understand fully what they mean now. But for me, it was very useful going back and looking at some of that testimony to see, you know, what PNM witnesses had said previously about these rec purchase programs. And I think the commission will rightly want to know, hey, why are we letting rec purchase programs, you know, go away? Don't we want people to be doing this? And you can formulate a better answer, I think, when you go back and study how this has been treated over a series of cases and not necessarily just this one case.
I think that's right, and we wouldn't have any objection to their being administratively noticed either.
Terrific, thank you.
Thanks.
Ms. Anaya, Alan, do you have any questions for Ms. Sanchez?
Yes, I do have one question.
Sure.
Ms. Sanchez, can you describe how the existing rec contracts will, I guess, be completed? And I understand there will be, your proposal is that there would be no new contracts after 2022, correct?
That is correct. The existing contracts will remain active until their termination date, as noted in the existing contract. No new contracts would be executed as of December 2022.
Thank you.
And I guess the only question I would have for you, Ms. Sanchez, you addressed this in your bench request, or the responses to my bench requests, and indicated that your P&M's perspective is that the solar installers are sort of doing the rec purchase contracts or having their customers sign them as a matter of course. And I guess I was just trying to figure out ultimately if that's just kind of an anecdotal conclusion P&M's reached, or if you've actively been out there kind of talking with these companies who are these solar installers. Am I right to think that some of these solar installers, that the homeowners don't end up owning the rooftop arrays? Is that correct?
So the question, to make sure I understand, is there are third-party owned systems that the contractors do eventually maintain ownership of.
And then in those instances, do the rec purchases go to the benefit the homeowner, or does it benefit the installation company?
The installation company.
Okay, so they're basically just kind of throwing this thing up on the top of a homeowner's house, and then they are getting the benefit of it. Is that more or less correct?
The homeowner still gets the benefit of the system, the solar system, but yes, the recs are of the benefit of the contractor.
Okay. So are you talking to these people and having conversations like, hey, why are you doing this if it's not actually, because it seemed to me a company would be perhaps more, aware of what's economically viable and what's not, right?
I don't know. We do talk to some of the contractors. We do not have that conversation of what's more economical for them. They have that with their customer.
So then I guess ultimately, yeah, so going back to sort of where I started with my question, is the belief that you're talking about in your testimony, how are you forming it? Like, what is that? What's the evidence for these beliefs?
We have had conversations with contractors when the capacity is at its limit, and they are unaware of it. So they are not watching the capacity limits. It's just a matter of habit that they go in and submit the application.
If the capacity limit happens, okay. So if the capacity limit's reached, is it the circumstance that P&M just rejects the application altogether?
P&M never rejects an application. What we do is the application will be either applied for as an interconnection only application, or the customer has the option of waiting to determine if capacity does become available, they can resubmit an application. We never reject an application.
If the capacity isn't available, does P&M, like if it's a $150 application fee, and maybe not in all instances, is that what I understood from your testimony? Is that correct?
The $150 application is for the small solar system. The 0 to 10, the price does increase for a larger system.
Okay. So if there's not capacity available, and let's assume it's $150, what happens to the money?
So if capacity is not available, typically we don't allow that application to even be clicked on. So the customer would only have the option to apply for an interconnection only application and pay that fee, or they can hold their application until capacity becomes available, or not submit their application.
Okay, so but you guys wouldn't, P&M wouldn't, take the customer's money if there's not capacity?
No, we would not.
Okay. And I suppose it's pretty, is it, I mean, I guess that question about like the capacity being available, is it how would a homeowner or a solar installer know whether capacity is available?
PNM is required. It is posted on PNM website. We post those typically on a monthly basis, sometimes weekly, to be able to identify what the capacity limits are and what is available.
Oh, so if I go to PNM's homepage, there's going to be links that take me to, hey, I can sign up for one of these programs. There is capacity. Is it? That's what you're saying? Yes,
it is on the pnm.com solar page and our application page when a customer goes to apply.
Okay. One of the questions I was asking in the bench request was sort of about the future of DG Rex. And I guess I'm asking at a sort of a broad level. I mean, it just seems to me that the momentum is all towards decentralized generation. I mean, I'm sort of asking you to assume some things with me, and you could maybe disagree with that. But I guess, should the commission be at all concerned about terminating these programs?
To the best of my knowledge, this, as mentioned in my testimony, solar will still, there are other benefits that are incentivized in terms of the solar, and this would not de-incentivize that.
Yeah. And if one of the commissioners said, well, we need everything we can to make sure people are signing up. And I mean, obviously, if it's counterproductive, as your one exhibit now with the correct price shows, well, people are losing money, so they shouldn't be doing that. I mean, what would you say to the commissioner who asked the question? Like, we need everything in our arsenal to ensure people are signing up to have rooftop solar. How would you answer them? And terminating these programs just seems intuitively wrong. I mean, what would be your response?
I would respond that as mentioned before, there are other incentives that are far more beneficial and economic to the customer other than these programs to still incentivize solar.
Do you have any plans in place for distributed generation, additional incentives? I mean, to your knowledge, that I don't really know what other incentives might exist for distributed generation projects. Like, I mean, I'm not sure if I'm using that word entirely correctly, but effectively ways to incentivize people to put solar on their roofs and then have financial benefits. Does PNM have anything in the works to continue to incentivize? Anything new?
Not that I'm aware of. I do not.
Okay. That would be all from me. Anyone else? Miss Anaya Allen, I see you pointed your. Go ahead.
I do have. Ms. Sanchez, you have not provided an analysis of whether or not larger systems are equally, I guess, financially not beneficial to the customer. Have you done that analysis, and do you know the answer to that question?
What analysis are you referring to?
For larger systems. So the analysis that you provided in Exhibit AS3 is for the small solar customers, I believe under 10 kilowatts. And what about the larger customers?
I have not done an analysis of the larger systems.
And to tag on, sorry, go ahead.
You're also seeking to terminate the REC program for the larger systems as well as the smaller systems?
It is for all 3 system sizes, correct.
And what are the fees for the larger systems?
That it is depending on the size of the system. The application starts at $350, and it's I believe $1 per additional kilowatt. So depending on the system size, the application fee changes.
Thank you.
Well, let me ask this question. Can that, I mean, is it a challenge to present that analysis, Ms. Sanchez? I mean, is there a reason why that wasn't submitted in this case?
The average residential systems are the smaller 0 to 10 kilowatt systems. So that was our analysis for that.
So if we ask as a bench request that P&M provide the analysis for the larger customers and just picking one as a, you could sort of default to like, well, here's a typical larger customer. Here's kind of the cost it would be. Here's the cost. Here's how much they're going to generate. And in terms of rec purchases, here's much they're going to likely get. Would you be capable of doing that?
I believe we would.
Okay, so I know Ms. Hurst does this fairly, hearing examiner Hurst does this pretty frequently in her hearings, and I will follow suit. But I will ask P&M to provide that analysis. And I think what Mr. Allen's question is a good one. Let's get some analysis here of the slightly larger array, in addition to the analysis that Ms. Sanchez provided as a chart in her direct testimony and then corrected in the supplemental. Effectively, just do the same thing, but for the larger program. Ms. Sanchez, is that clear? Like, do you need me to clarify anything?
I guess just on the clarification of the system size, are we just picking any size? There are 0 to 10, 10 to 100, and 100 to a megawatt.
I guess, I mean, like what we'd want to know is sort of the representative sampling of here are the most popular folks in these groups, or here's sort of the median or the mean, whatever the better way would be statistically, and then just offer that. I mean, I'm not asking for I don't think we need endless analysis, but just providing some indication as to what the analysis would be for the larger customers. I mean, you can designate. I mean, P&M knows what's more typical than another, so I would just rely on your judgment to do that.
Okay. Would one size be okay? One different analysis, or you want to?
Yeah, I would want to see an analysis for each. One analysis for the 10 to 100 and one analysis for the 100 to a megawatt. I mean, the question really is, P&M's contention is that this program is not economically beneficial for the customer. And so you're demonstrating that for the 0 to 10 small systems. Can you demonstrate that as well? Or is that also accurate for the larger systems in both size categories?
Okay.
And I suppose to the extent to which, that's a dynamic question that would be contingent upon, a variety of factors. Well, so sort of, I can understand that response, but, still, I think P&M can provide the analysis it's done that we've received, and then sort of here's kind of a benchmark for this other group and then the other group. That seems reasonable. So P&M can supply that as soon as they possibly can. Mr. Aikenhead and Ms. Kelly, is that acceptable?
We can work on that. How would you want us to submit it to you?
You just send it by email,
Okay.
or you file it on file it on eDocket as responses to bench requests at the hearing on today, September the 8th.
Okay.
And that gets filed, and then I will ensure that Mr. Lee has that and adds that to our record. And whatever it would be to do that. That's interesting, actually. I'll have to think about that. But anyways, that's how I'd like for you to supply it.
Okay.
Ms. Allen, do you have any other questions for Ms. Sanchez?
I do not. Thank you, Ms. Sanchez.
Ms. Sanchez, I don't have any further questions as well. Thank you very much.
Thank you.
P&M, your next witness?
P&M is going to call Nick Phillips as its next witness.
Very good.
Thank you, Mr. Hearing Examiner. Ms. Kelly may have already called Mr. Phillips, but Mr. Phillips will be the next P&M witness.
Sure. I see we have a blank screen for P&M witness, so I guess we're just waiting for him.
Correct. We are in separate rooms, so the witnesses will swap out and we'll get going. Thank you.
Mr. Lee, could you swear in Mr. Phillips, please?
Mr. Phillips, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter up pending should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Mr. Aikenhead, go ahead.
Thank you. Good morning. Would you please state your full name for the record and explain what your position is with P&M?
My name is Nicholas L. Phillips, spelled NICHOLASLPHILLIPS. My title is Director of Integrated Resource Planning with the Public Service Company of New Mexico.
Thank you, Mr. Phillips. You should have two documents there with you, and we'll introduce into evidence two separate exhibits with you. We'll start with what's been pre-marked as P&M Exhibit 2. Do you have that document?
Yes, sir, I do.
What is that?
That is my pre-filed direct testimony in this proceeding.
Did you prepare your direct testimony, or was that prepared at your direction?
Yes, it was.
Thank you. Are there any errors in your pre-filed testimony that require correction?
There are no errors in the testimony that require correction. I would like to clarify, as we have indicated in some compliance filings with the commission and other dockets, some commercial online dates for projects that will be used for, that will generate RECs in 2023 have shifted back, but that does not change the proposed plan for compliance. We still are able to comply. So there's no corrections to anything. That is just a clarification.
Thank you for that. And with that in mind, if I ask you the same questions today that you responded to in your testimony, would your answers be the same?
Yes, they would.
And is that testimony true and accurate to the best of your knowledge?
With the clarification I just made, yes, it is.
Thank you. I'll go ahead and move what's been marked and uploaded as P&M Exhibit 2, the direct testimony of Mr. Phillips.
Any objections? I don't hear any. P&M Exhibit 2 is admitted.
All right. Thank you, Mr. Hearing Examiner. Mr. Phillips, let's go on to what's been pre-marked and uploaded as P&M Exhibit number 3. Just to make sure, do you have that document in front of you?
Yes, sir, I do.
Thank you. And what is that exactly?
That is my pre-filed rebuttal testimony filed in this proceeding.
And was P&M Exhibit 3 prepared by you or at your direction?
Yes, it was.
Are there any errors that require correction in P&M Exhibit 3?
No, there are not.
If I ask you the same questions today that you responded to in writing in P&M Exhibit 3, would your answers be the same?
Yes, they would.
It is your testimony true and accurate to the best of your knowledge in P&M Exhibit 3?
Yes, it is.
Thank you. I'll go ahead and seek to move into evidence what's been pre-marked as Exhibit 3.
Objections? Hearing none. P&M Exhibit 3 is admitted.
Great. Thank you, Mr. Hearing Examiner. No further questions for Mr. Phillips at this time.
Great. And before I pass Mr. Phillips for any questioning to the interveners, I'll just do what I did with Ms. Sanchez. Mr. Phillips, you submitted supplemental testimony in response to bench requests of August 23rd, 2022. P&M submitted this on Dropbox anyway, in their exhibit list as P&M Exhibit 4. You're familiar with that document?
Yes, I am, Mr. Hearing Examiner.
And you're responding to my questions there. Are your answers accurate and correct?
Yes, sir, they are.
And if I asked you these questions today, would you testify in the same fashion as we sit here now?
Yes, I would.
As just a preliminary matter, when you're talking about the 2023 online times, the project completion timelines, is everything up to date as much as can be?
Let me review the responses. The most recent compliance filing that we had filed was at the end of August.
Okay.
And I just want to make sure that this is correct. It should be. I mean, we received this in September, if I remember right.
Yeah, and I understand it's kind of a tricky question. It's a pretty dynamic situation, so.
So I think some of the dates, at least one of the dates, has changed a little bit from what was represented in this. The questions that you had asked me to respond to reference to the compliance notice dated July 29th, 2022.
Okay, so which part of your testimony are we talking about?
So on page 5 of my testimony,
this is the supplemental, right?
The supplemental testimony, page 5, and the question and answer beginning at line 11 that discusses the 50 megawatt Hickoria project.
Okay.
That references, no, never mind. I was thinking April 1st, but March 31st is the online date that was still referenced in that filing. So yes, I'm sorry, this is correct. My apologies.
No problem. Okay, good. So I will admit, and I think I've done this satisfactory. Would you? Well, you've just said to me that the testimony is accurate and correct to the best of your knowledge. That you would answer the questions the same way if asked today, and you don't have any corrections. Is that correct to the supplemental?
Yes, Mr. Hammerser, that is correct.
Great. So I would propose to admit Mr. Phillips' supplemental testimony in response to the bench requests of August 23rd, 2022 as Commission Exhibit 2. Is there any objections to that? I don't hear any, so that will be admitted as described. Okay. We will have time for questioning, and we would go first to Ms. Gould. Anything for Mr. Phillips?
Yes, thank you. Good morning, Mr. Phillips. How are you doing today?
I am well. Good morning, Ms. Gould. How are you?
Doing well. We know each other, but for the record, my name is Kelly Gould, and I represent New Mexico Affordable Reliable Energy Alliance, also known as NMAREA. So first, I would just like to ask you some general questions I have regarding your testimony.
Sure.
If you would turn to page 1, line 14.
Of my rebuttal or my direct?
Of your direct testimony in this case. And you state, as Director of PNM's Integrated Resource Planning, I supervise the team that is responsible for developing PNM's resource plans and the regulatory filings to support those resource plans, including the annual Renewable Energy Act. Is that accurate?
I believe you've read that correctly.
So is it safe to infer from that testimony that you had a direct supervisory role over Mr. Gutierrez in his testimony?
Yes, Mr. Gutierrez is a member of my team.
Okay, and does he report to you then?
He reports directly to me.
Okay. So I'm asking this question to see who to ask my questions to. What input did you have over his testimony?
I review his testimony. He develops it independently, but we review it. And, in terms of if there's questions that come up, we will work on those questions together to make sure that we have a cohesive way of presenting the different portions of the case. There's indications in the testimony where I might have directed him to do something.
Okay, so if I'm asking you a question and it's better suited for Mr. Gutierrez, just please let me know that, okay?
Yes, ma'am.
page 7, still on the direct. I guess we're going to start on page 6. I'm going to read again. So we're going to start on line 22. You state integration, I guess line 23, integration of renewable resources requires carrying sufficient flexible resources, including battery energy storage systems and flexible gas generation, and committing increased amounts of operating reserves in order to manage the variability and uncertainty of variable energy resources. Oh, sorry. Well, did I read that correctly?
You read that correctly.
Does that suggest that there's a cost to integrate renewable resources above the cost of what the resource, the cost of the resource?
I think the answer to that is that it depends. The cost associated with it, for example, from a battery energy storage system, there may not be a cost to the charging or discharging of the battery depending on what it is charged with. Certainly if it was a gas-fired generator or you're committing reserves that are relative to a resource that has a variable operating cost, to the extent you are increasing or decreasing output, that could include a cost. Now, one would have to, in order to fully understand the entire picture, assess what other benefits might be levied to the system through the ability to increase the integration of the renewable resources. So it's not just a cost side, there could be a benefit side as well.
Okay, it just seems from, I guess, the Q&A, it says, please describe the strategies PNM uses to minimize cost of renewable energy integration. That seems to imply if you're minimizing costs for renewable energy.
Kelly, I'm sorry, Miss Kelly. Please start again and slow down.
I'm sorry, thank you.
Please describe strategies PNM uses to minimize.
Yeah, I'll just start over. The Q&A, the beginning of the Q&A, it says, please describe the strategies PNM uses to minimize costs of renewable energy integration. And to me, the way I read that, the word minimize and the strategies used to minimize seems to imply that there are costs and PNM is trying to minimize those costs. Is that an incorrect interpretation of that question?
I think the question specifically references a section of NMAC 17.9.572.14 and requires us to discuss the strategies of minimizing costs. And part of minimizing costs is reflecting the total costs and benefits associated with the strategy. And my response was to say that while we might say that there could be a cost associated with this one particular component, and there is a much more expansive answer than what we have just discussed, by integrating renewable energy, there could also be a benefit, and you want to make sure to consider both sides of the equation.
Okay, and so does PNM do that?
Does PNM do what?
Does PNM track the costs associated with integrating renewables and also track the benefits associated?
The question itself says, what are the strategies? And I was describing the strategies. Later in the response, we do talk about, for example, reductions in total operating costs from participation in the EIM, and that is through combinations of integrating additional renewables.
I don't know if that answered my question. My question, I guess I'll break it into two parts. Does PNM track the added costs, the costs added to integrate renewables into the system? Does PNM track that?
There is no specific line item or otherwise breakout of just the integration costs associated with renewables. We operate the system and we do it in a way to minimize the total operating costs.
Okay, so your answer would be no, PNM does not specifically track those costs.
Yeah, that's what I just said.
Okay, thank you. So moving to Line 7, let's see, let me read it first before okay, design of individual renewable facilities with higher inverter loading ratios can also decrease variability of output during peak production periods, though the economics must be compared against the undelivered energy from overloading the inverters. Do you see
Ms.
that
Gould,
portion of
sorry,
the
for the record,
testimony?
can you say where that is on the testimony? I want to
That's
follow up.
page 7, line 7 to 10.
Thank you.
Are you with me, Mr. Phillips?
Yes, I am.
Okay, I didn't understand what that meant. Could you explain what you mean by that?
Yes. So in the design of an inverter-based system, you could put more than, say, a 1-for-1 amount of capacity behind the inverters. And so if we take the example of, say, a solar facility, a lot of times the design uses a 1.3 inverter loading ratio. That means there's going to be more solar panels if they all were at maximum output, very sunny day, noon, maximum solar irradiance. The actual output might be 1.3 times what the inverter could allow through into the grid. And so there's actually a little bit of curtailment happening behind the inverter or through the inverter. And so if you have a very sunny day and then a cloud comes over, you could still maintain maximum output through the inverter or what the inverter is rated for, because you have a little bit of energy that was being curtailed. That's what I was talking about here when I said, it could decrease the variability during peak output periods. So it's a question of how much do you want to pay for the panels that are behind the inverter versus how much energy can you let through the inverter during the time periods, and which becomes the economic breakpoint.
And just for clarification, Mr. Phillips, the inverter is changing it from, is it AC to DC, or is it the reverse?
It's the reverse. The inverter is controlling what is delivered to the AC grid.
I see, because the panels themselves generate in direct current. Is that right?
Yes, sir. That's right.
Okay. Thank you. Sorry, Ms. Gould. I just wanted to clarify.
No, that's okay. Thank you. And just is that in real time? How long does that extra capacity stay? This isn't, you know more than this than I do, but if you can answer, how long does that stay in the inverter? I know it doesn't stay in the inverter, but for the purposes of my question. I mean, the inverter's not a battery, right? So
right, there's no storage that's going on. What's happening is the panels are producing electricity as the sun is irradiating the panels. To the extent, in my example, there's a cloud that comes over the panels, and the cloud cover reduces the irradiance, but there's still enough irradiance to where the rated ability of the inverter is still reached. You don't have a dip in production coming through the inverter, so there's no storage. It is in real time. You could have a coupled DC system where you have a battery charging behind the inverter, or you could have it AC coupled, but that's a little bit different than the example that I was talking about.
okay, thank you. So it's more of a function of having more solar panels than what you need, kind of.
And I don't think I would agree with saying than what you need. It's more solar
than what
panels.
it's rated for.
It's more solar panels than what the inverters are rated for. Now, depending on if P&M were to be the constructor or if it was a third-party developer, any individual entity will assess their own economics and determine what the correct sizing of the system is to maximize the benefits of that system. Typically, it's done at about 1.3 inverter loading ratio.
Okay, thank you. Same page 7 of your direct testimony, line 12, you're discussing the EIM, which is the energy imbalance market. And you state that P&M achieved 12.5 million in savings in 2021. I know that there's a separate filing on this, but was the $12.5 million actual savings, or was part of that avoided costs?
It's net savings. It's the combination of either additional revenues through the operation of generators in the market, or it could be purchasing power through the market and a reduction of operating costs for our generators. So it is a net number.
Okay, and I'm not seeing any of the hearing examiners. Am I?
I'm not seeing them either. This is the reporter. I'm going off the record.
Okay, thank you.
I don't know if that's a comment on your questioning, Ms. Gould.
For what it's worth, I got bounced off of here for about a minute, say 5 minutes ago. So
Oh, you did? Okay.
yeah,
I see them coming back in.
they're coming back.
Oh, we're back on.
And Miss Anaya Allen. Oh,
We're back.
Okay, well, we stopped for you all.
Good. No, we just went offline. Did the Zoom meeting continue?
Yes, sir.
But we got thrown off. Okay, so I was just sitting here, and as Mr. Phillips was answering, we started to get some choppiness, and then all of a sudden, Zoom just went away, and it said your network bandwidth is low. So I suspect either somebody did something in the. Mr. Borman, are you in the building right now?
I am not, but as I indicated while you guys were gone, I had an outage about 5 minutes ago. That sounds pretty similar to yours.
It's Miguel's calling me. Our IT department. Anyways, sorry about that, folks. I had no control over that. It was the interwebs. They sometimes don't work too good. So
we are off the record, Judge.
Great. Yeah, no, that's fine. Thank you. Gosh, I will have the record up until when I got thrown out. But Ms. Gould, can you go back in time and just continue your questioning from the point that Miss Naya Allen and I, is she on? Is she back now too?
She is on, yeah.
Great.
I will just re-ask my question if that's okay. And then
Please.
If that's okay that Mr. Phillips just re-answers.
Yes, thank you.
Okay.
Mr. Lee, we'll go back on the record now. Thank you.
On page 7 of your direct testimony, line 12, you are talking about the energy imbalance market, the EIM, and you state that PNM achieved 12.5 million in savings in 2021. Do you see that?
Yes, I do.
Was that $12.5 million actual savings, or was that avoided costs?
In my previous response is that it is both, or it is net savings. There's opportunities for additional revenues for PNM through the energy imbalance market by operating generators more and selling the output, or there could be avoided costs of running a generator that you don't have to run because you're able to purchase power cheaper through the market. So the $12.5 million in savings is a net savings number that is a combination of both savings and avoided cost.
And
I should say operational savings for units and avoided cost for not running units and purchasing power.
But since it's net, the $12.5 million is actual dollars. Is that correct?
Yes, that's correct.
And I believe you answered in your response to the hearing examiner's bench request that those actual dollars are credited to customers through the fuel clause. Is that accurate?
Yes, it is.
Thank you. So I am going to switch gears and I'm going to refer you to Mr. Gutierrez's direct testimony. It has yet to be admitted into evidence. Mr. and Madam Hearing Examiner, is there any procedure you'd like me to follow, or can I just ask him questions?
You can just ask him questions. I've had these conversations with the other hearing examiners, and for purposes of cross, you can utilize such documents.
Okay, so starting on page 5 of Mr. Gutierrez's testimony and going to page 10, he makes the distinction between resources PNM considers, quote, RPS resources, and RPS stands for Renewable Portfolio Standard. So let me just repeat. So PNM makes a distinction between RPS resources and resources that PNM considers, quote, system resources. Is that your general understanding of Mr. Gutierrez's testimony on those pages?
Allow me to just run through those 5 pages very quickly. Sure. As I'm doing so, what I can say is, I think that generally speaking, all resources provide energy to the system. There are certain resources which are providing renewable attributes, and some of those resources are sought for recovery through the RPS rider, where others are not sought for recovery through the RPS rider. So I don't want to say that there are, a separate and distinct piece to these, because all resources contribute energy to the system.
Thank you for that. I guess on page 8, line 4, Mr. Gutierrez, there's a Q&A that says, what system resources is PNM using for RPS compliance?
Okay, let me read that Q&A very quickly. Okay.
And then on page 6, it says, please describe PNM's existing solar RPS resources.
Yes, I'm with you.
So the way that I'm understanding Mr. Gutierrez's testimony is there are 2 buckets. There's, quote, system resource bucket that are renewable resources that are not being recovered through the RPS rider. And then there's RPS resource bucket, which are renewable resources that are being recovered through the RPS rider. Is that fair?
Yes, there's different cost recovery mechanisms for system resources as opposed to RPS designated resources. All resources on the system that are generation resources will provide energy to the system, though. Some of them produce RECs. Some of them are recovered through the RPS rider. Some of them are recovered through other mechanisms such as base rates or the fuel clause.
Okay, so just going off, I understand your distinction and I appreciate that, that all resources are system resources. But just going off how Mr. Gutierrez has classified the resources, he does seem to there does seem to be 2 categories. And on page 8 is what I want to talk about, and he calls those system resources. If there's another way we could talk about them that would be better, let me know, but that's how I've talked about them.
No, I'm fine with the way that you were speaking about them. I'm just clarifying that what we're really talking about here is the cost recovery mechanism. It is not the fact that some resources do not provide energy to the system and only provide, RECs or something of that nature.
Okay, great, thanks. So how does PNM determine whether a resource is a, quote, RPS resource, whether it recovers the cost of that resource through the RPS rider, or a, quote, system resource where it recovers that resource, the cost of that resource through other mechanisms?
So that's discussed in my rebuttal testimony, I believe at page... Beginning on page 3 and continuing through page 5.
So what I understood from your rebuttal was I guess I'd like you to just answer my question rather than answering my own question. I mean, is there a definition that PNM has for a quote RPS resource versus a quote system resource?
Well, if we were to go through the resources in Mr. Gutierrez's testimony, we are following the stipulation in the 2014 case, as well as the hearing examiner and commission's recommended decisions and approved orders in case number 19-00195-UT, as well as 21-00215-UT. And that's what I discuss in my rebuttal testimony, in particular on page 3 and 4. And so that's really what we're going by, is making sure that we're complying with the commission's approved methodology on cost recovery. I think that as the system goes more and more renewable, this could be re-examined. I would agree with Anna Maria's witness, Mr. Meyer, that the proper place for that is in a rulemaking. And that's something that I've indicated in my testimony as well. But for the purposes of this plan, we are following the approved cost allocations and recovery methods that were dictated by the commission.
So in 19-00195, did PNM request or ask the commission to use those recs for RPS compliance purposes? If you recall.
I do not recall.
And if you recall, was the use of the cost, was the recovery of those costs for those resources ever considered to be recovered through the RPS rider?
Mr. Hearing Examiner, I'd like just to preserve an objection on the record, if I may.
Okay, Mr. Aikenhead.
I want to just object on grounds that we're straying from the substance of Mr. Phillips' direct testimony and rebuttal testimony. I believe he's answered Ms. Gould's question regarding this distinction in the rebuttal testimony, but now we're just starting to stray into information from other dockets. So I'd just like to object on those grounds and see if we can stay within the confines of this proceeding.
Can I
Okay.
respond, Mr. Hearing Examiner?
Yes, but I just want to clarify before I go to you, Ms. Gould. Are you objecting to the specific question, or are you just objecting as a general matter?
I'm objecting to the specific question referencing the separate docket, Mr. Hearing Examiner, on relevancy grounds and grounds that we're getting beyond the scope of Mr. Phillips' testimony in this RPS proceeding.
Okay, Ms. Gould.
Yes, I think as you mentioned earlier in this proceeding, all these dockets kind of overlay one another. And in order to understand what we're dealing with here, it's necessary to understand what happened before. Mr. Phillips specifically references both of these dockets, 19-00195 and 21-00215. He states that that's the basis for the categorization that Mr. Gutierrez has in his testimony. And I believe it's fair to ask and dive into how they've determined that categorization. I also believe that in Mr. Phillips' testimony, rebuttal testimony, and I'll have to look for it, he states that the commission approved recovery of the costs of the 195 and the 215 resources through the fuel clause and not the RPS rider. And I just want to make clear that the RPS rider was never addressed in either of those cases.
Okay, and those are matters that, I mean, I suppose would really ultimately be assertions proved by the pleadings or the recommended decisions in the final orders in those cases. I mean, I'm aware of where you're going with all this, Ms. Gould. My broader concern is that to the extent to which, the questions, like the last specific question you asked Mr. Phillips said, I don't know, more or less, which is fair. I mean, he may not recall. So I think the line of questioning isn't inappropriate. It's just, in some level, you're talking about a broader macro concern to which Mr. Phillips has said that gets dealt with in a rulemaking. So
yes, I guess if he doesn't know the answer to my question, he's free to say that he doesn't know.
right. So I mean, to the extent to which there's an objection by PNM, I mean, I don't think they're asking me to specifically rule. I guess what they're really saying ultimately is, if this has been already asserted in the responsive testimony, and this is to be addressed elsewhere, I don't think we need to spend a whole lot of time on it. But in any case, the objection's noted. And Ms. Gould, why don't you continue?
Yeah, so what I'm really trying to get at is how PNM determines the difference between the cost recovery mechanisms. And what I'm understanding is it's just based on what case PNM requests recovery of these resources. Is that
Okay, yeah, that's a question for Mr. Phillips, correct?
correct? Mm-hmm.
I mean, as I've indicated, the distinction that was laid out in Mr. Gutierrez's testimony, if we go back to where the commission said we should recover those costs, that's where that is linked to. You know, as I mentioned, I think that this should be revisited. It should be revisited in a rulemaking. There's going to be a number of things that ought to be considered as the system transitions from 20 to 40 to 50 to 80% renewable, and how those costs ought to be recovered. When I think about system versus just RPS, what I would say is, system resources are being brought on for the full benefit of the system, for the efficient and reliable use of the system, usually stemming from an all source type RFP. An RPS specific resource, in my mind, is something that is going to be more linked to a procurement that is done specifically to meet the renewable portfolio standards, and may likely be a more limited type of RFP or procurement. Now, again, I think that there needs to be reexamined going forward. And part of what would need to be reexamined is how you may want to differentiate costs between fuel and base rates and RPS. And perhaps that shouldn't be a binary decision. I think that right now what would happen is if you were to put everything, and I understand that from Mr. Meyer's testimony, one of the things that NMary would be proposing is taking all of the costs for any renewable resource and putting those into the RPS component could create a cross subsidy flowing from non-voluntary customers to voluntary customers. And so to ensure that we do this in the correct way, if we are going to re-examine the way we would look at the categorization, we need to do it holistically, not in a one-off approach.
I agree, but currently PNM is taking the opposite approach and not assigning any costs of these renewables to the RPS. Is that accurate?
I disagree. There are renewable costs going into
From
the RPS.
From 195, from the dockets 195 and 215.
Well, none of the costs or none of the recs that would be needed from the resources in 195 or 215 are needed to comply with the RPS requirements in 2023.
Okay,
so
but those
we
rates
have
are
plenty
being
of time.
Wait.
Sorry.
Yes, one at a time. Question and answer
All right.
format for
Thank
benefit
you.
of our court
I
reporter.
apologize.
Thank you. Just want to make sure Mr. Phillips has an opportunity to fully respond. Thank you.
Yep.
So if we were to look at Mr. Gutierrez's testimony, we were to look at and especially my response to Mr. Hearing Examiner's bench request, PNM from its existing resources and those that are recovered through the current RPS calculation are sufficient to cover the RPS requirements in 2023 and 2024. Again, PNM is not stating that we shouldn't examine this. I think that we have plenty of time, and we would do it through a rulemaking and make sure we look at this holistically. One of the other things I would bring up is the fact of the Energy Transition Act requiring that all RECs used for compliance must be bundled with the associated energy products. Does inextricably link them together and makes it more difficult to separate them out. We can look at how we might do that. But as we move forward, like say if we have an 80% renewable system, and then there's the voluntary customers on it as well. I mean, one thing that I might consider is if you do it like you are today and you put everything into the RPS bucket, there's a lot of renewable energy that would be used in storage devices and other things that would be serving the reliability requirements and other system needs of voluntary customers as well that may not be being paid for. So that's why I'm saying that we need to make sure paid for by those customers. We need to make sure that we are really looking at this closely, because as the system moves forward in time, it becomes more and more renewable, and there is less and less of a distinction.
Is there any rule or law that you can point to that provides the basis for the distinction that PNM is making in this filing?
I'm pointing to the commission's orders, which they had indicated the cost recovery mechanisms appropriate for those resources.
Okay. And PNM is in control of which dockets it requests resources in, is that correct?
I mean, PNM files applications with the commission for the approval of resources either through PPA or CCN rules. Yes.
And you would be, PNM would be the one that would determine whether they ask for a resource in an RPS docket or in a different docket, is that correct?
PNM would indicate whether they believe that a resource was brought on specifically for RPS compliance or was serving the full needs of the system for efficient and reliable service.
Okay, and then I know you're not an attorney, but you did just talk about the bundled RECs, and so you are aware of the provisions of the Renewable Energy Act and the statutory mandates that PNM must adhere to comply with the mandates in the Renewable Energy Act. Is that correct?
Could you clarify the question a bit more? Is there a specific provision? I am not, I'm versed in every single portion of the REA.
You've read the REA, and you, if you can't answer the question, you can just say you don't know, but you are responsible for ensuring PNM's compliance with the REA. Is that correct?
Yes.
And you're aware that there were amendments made to the Act in 2019?
Yes, I am.
And that before 2019, PNM was allowed to use standalone RECs to comply with the RPS mandate?
That's correct.
And by standalone RECs, I mean PNM could purchase RECs without the associated energy. Is that your understanding?
That's correct.
And in 2019, the legislature amended the statute so that PNM and the other utilities no longer could use standalone RECs to comply with the RPS mandate.
I think there's a distinction that we should make there. PNM, the utility, on behalf of non-voluntary customers, has to use bundled RECs and energies. The voluntary customers are not bound by the RPS requirements, and they could themselves, because they are not bound by the RPS requirements, potentially use unbundled RECs.
I guess I didn't finish my sentence. Thank you. So the PNM could not use standalone RECs to comply with RPS mandates.
PNM, the utility, on behalf of retail non-voluntary customers. That's
for
correct.
RPS mandates. I mean, you said that voluntary customers are not subject to RPS mandates, right?
Right. I'm clarifying that PNM, the utility, on behalf of its retail non-voluntary customers, must use bundled RECs and energy.
Okay, and by bundled RECs, we both mean that PNM now has to purchase the renewable energy associated with the REC for RPS compliance. Is that correct?
The energy and the REC have to be delivered as a bundled product. So they are now, in my mind, inextricably linked. There's no separation of the two.
Okay. And you're also aware that in 2019, the legislature amended the statute to allow for customers to participate in voluntary programs to purchase more renewable energy than is required by the RPS mandates?
Yes, I am aware.
And the statute states that those voluntary program customers do not have to pay for costs associated with RPS compliance?
That's correct. And none of those customers are charged, or in the event of some customers are not charged, other customers are credited back the RPS rider cost.
So don't you think it matters how PNM categorizes its what it calls RPS compliance costs?
I'm going to object to the question. Mr. Phillips has answered the question about categorizing resources now at least 3 times. And we're back to square one again. I think we've established that this issue would be better dealt with in a rulemaking proceeding. We're getting into the weeds on an issue that isn't necessarily germane to compliance in the current application. So I'd just renew the objection to relevance, and
well, I'll sustain in the sense that it's asked and answered. And so, Ms. Gould, I know your arguments. I know what you're saying. I believe you've made your point.
Yeah, my question was different than what I had asked before, because I'm asking whether or not Mr. Phillips believes it's in compliance with section 62-16-7-B3. That's not a question that I asked before, and I disagree with the categorization that this is better dealt with in a rulemaking. I think we're making our record in this case because we believe it has to be dealt with in this case, and we're asking for a commission order for prospective treatment of this issue. And so the hearing examiner has not said that it's better dealt with in a rulemaking, and neither has the commission. So I don't think that PNM's assertion that that issue is settled is valid.
Are you asking the question as a matter of fact? Or are you asking Mr. Phillips to make a conclusion of law?
I'm asking, as his job as director of PNM's integrated resource planning, if the way that PNM categorizes what is an RPS compliance cost affects section 62-16-7B3.
How is that a fact question?
Well, he is in charge of ensuring that PNM is complying with the law.
Mr. Aikenhead?
I just want to object that the question clearly calls for a legal conclusion.
I believe it does too. Overruled. Or sustain the objection. Sorry.
Okay.
I forgot we were in the. Yeah.
Thank you. In your rebuttal, you talk about, I believe it's called the Mesa del Sol project. Is that the project in 14-00158?
Could you direct me to a page in my rebuttal testimony, please?
Just generally your rebuttal.
Can you please direct me to the page you're referring to?
Well, I'm on page 13. It says line 14, the stipulation in case 14-00158. And I'm just asking.
Sorry, I'm Ms. Gould. There is no 13 to the rebuttal testimony.
Page 3, line 13.
Oh, 3. I'm sorry. I thought you said page 13. My bad.
I was just asking what the name of that project was. I wasn't referring you to a specific part in your rebuttal. I was just asking if the project approved in 14-00158 was called the Mesa del Sol project.
I don't know off the top of my head.
Okay. Oh, I think that Mr. Gutierrez calls it 2015 PNM solar PV project. Okay.
That I would agree with.
So, okay. All
right, Miss Gould, could you restate what Mr. Gutierrez called it? You were breaking up there a minute.
Sure, I believe he called it. I'll have to find it again. (2015) PNM solar PV.
Thank you.
And just Ms. Gould, real quickly, in discussion with Mr. Lee about the proceeding, we have agreed that we will, in fact, take breaks at the set times of an hour and a half. We are all human and have biological needs. This is appropriate. Do you have much more questioning to go, or do you where are we?
I do. I have still a lot.
Then we'll take a 5-minute break. It is 10:32. We'll come back on my cell phone anyway. 10:32. We'll be back at 10:37. And please be sure to mute yourself and turn the video off. We're on YouTube.
Thank you.
You're talking about.
Everyone present. There's Ms. Gould. So I'll wait for Miss Anaya, hearing examiner Anaya Allen to come on. Okay. All right, Mr. Lee, let's go back on the record. And Ms. Gould, you can continue your questioning.
Okay. Can you hear me?
Yes.
I'm gonna move on. In case 21-00215, you requested 300 megawatts of solar PPA combined with 150 megawatts ESA of additional resources, in part to help balance system load due to high penetration of renewable energy. Is that accurate?
If you could point me to something where the specific statement was made, that would be useful. We did request 300 megawatt solar, 150 megawatt battery storage project, designated the Atrisco project as a portion of the filing. There was other resources included as well.
What was the purpose of that, the requesting those resources?
The purpose of the filing was to replace the lost lease capacity from the Palo Verde nuclear generating station, as well as to address requirements associated with the increased reserve margin that we believe we needed to efficiently and safely serve our customers.
When you say increased reserve margin, would that also be additional resources to, in part, to help balance system load?
Portion of those resources, the storage pieces in particular, would be used to balance load. It would serve multiple functions. Most resources on our system do serve multiple functions.
Okay.
So all of the storage pieces that in that filing, there was a 100 megawatt 2-hour standalone storage project. There was a 150 megawatt solar, 40 megawatt paired energy storage project, and then the 300 megawatt, 150 megawatt project you just described. The storage components of all three of those would be used to ensure system reliability, balance loads and resources, et cetera.
What's the total megawatts of just the solar that you just listed off?
Included in the filing, there was 450.
And what was the megawatts of the Palo Verde leases you were replacing?
It was 104 megawatts in 2023, an additional 10 megawatts in 2024.
So there was quite a bit of extra resources being requested in that case above and beyond what was being retired. Is that accurate?
On a nameplate basis, but you can't compare solar resources to nuclear resources and say 1 megawatt is equivalent to 1 megawatt. You have to look at the effective load carrying capability. The application that was included resources to both replace the energy from the Palo Verde nuclear generating station leases that were being returned, as well as to maintain system reliability, including the increased reserve margin. And that package put together included 450 megawatts of solar and 290 megawatts of combined 2 and 4 hour storage.
Could you turn to page 49 to NM Area Exhibit 4?
Thank you. Okay, what page would you like me to go to?
Page 49.
And Mr. Hearing Examiner, at this point, I'd like to object. This exhibit has not been admitted into evidence, so to the extent we're going to read portions of this exhibit prior to its admission, I would object on those grounds.
Ms. Gould?
Well, this is the direct testimony of Nicholas L. Phillips dated April 2nd, 2021. This was his testimony in 21-00215. I would ask the hearing examiners to take administrative notice of this document, and I would like Mr. Phillips to read from this document. I think it provides insight into how PNM is planning its system, including its renewables.
And I'm sorry, Ms. Gould, this was New Mexico Area Exhibit 3? Is that time?
Number 4.
Number 4. Is there a reason, Mr. Aikenhead, that I can't take administrative notice of this?
My understanding, Mr. Hearing Examiner, is that the document has to be relevant as a threshold issue. Not sure, there's been no foundation laid, number one, but number two, from a relevancy standpoint, it's unclear why Mr. Phillips' direct testimony in another proceeding from 2021 would be relevant in the RPS application, especially since, as far as I can tell, the RPS compliance for 2023 and 2024 is not being contested here. So again, we seem to be straying from Mr. Phillips' relevant and associated testimony in RPS and getting down a rabbit hole that might not be all that useful in deciding the issues at hand.
And Ms. Gould, I presume you have an answer to that.
Yeah, Mr. Hearing Examiner, PNM is using the recs from Atrisco in its tables for while they're not being used for 2023 and 2024 compliance, they are being banked, and I will get into questions regarding that banking as I continue my cross. However, it's NM Area's position that these resources should be included or at least accounted for when PNM makes its determination, its revenue requirement determination. And we are asking for the commission to make a prospective order on PNM to do this in 2024 while we're not asking PNM to recalculate its revenue requirement in 2023. We don't believe they did it correctly. And because they're using the recs from Atrisco in this case, I think the docket where Atrisco was approved is relevant.
And this is more broadly going to your point about how they determine what's RPS costs and what is not. Is that
that's correct?
Yeah. So I think it's relevant to that line of questioning. So I'll allow Ms. Gould to ask questions about this, and then I know because this was admitted in the hearing in 21-215. Specifically on December the 3rd of 2021. So Mr. Phillips' testimony here should be fair game for purposes of administrative notice. So Ms. Gould, go ahead.
Okay, NM Area Exhibit number 4, page 49, line 9. If you could read from line 9 to line 15 out loud, please.
So the question itself starts with, is there any basis to continue the use of this legacy fixed percentage as a target for the planning reserve margins? You've asked me to start reading approximately 3 sentences in, so this will not be the full response to that question. Increased renewable.
If you would feel more comfortable to read the full response.
Well, let me ask you this, Ms. Gould, is it possible for the benefit of our court reporter that Mr. Phillips just familiarize himself with the writing there rather than reading it all, or do you very much? I mean, is it essential that he read it out loud?
Well, I can just read and ask a question. He just didn't seem to answer the question that I was asking, and so I was directing him to a part of his testimony where he agrees with the question that I was asking. So what I was trying to get at on page 49, line 9, is increased renewable penetration on PNM system poses increasing challenges such as larger magnitudes of intermittent generation, changes to expected capacity contribution during peak periods, and reliability concerns during non-peak periods. Do you still agree with that statement, Mr. Phillips?
I still agree with that statement. I think that it's important to recognize that this testimony that we're isolating one sentence from is, I believe, close to 80 pages, and all of it needs to be taken together to understand the reasons for the procurement that was proposed in that case.
Okay, so my question is, why didn't you ask for approval of a Trisco in one of your RPS cases? If part of the reason it was asked for is to provide, just to ameliorate the challenges posed by increased renewable penetration.
I believe I just answered that question in stating you have to read the entire testimony to understand the rationale for the full package of resources. Trisco and the other resources were chosen as a part of a least cost portfolio subject to certain policy considerations. And there was an additional benefit by those resources, some of them being able to generate renewable energy certificates such that it could defer future RPS procurements. This portfolio is put forward in the sense that it will serve the full system needs, maintain reliability, and provide low-cost service to our customers. This was not done as an explicit RPS procurement.
But you said certain policy considerations. Were some of those policy considerations the RPS compliance?
No, the policy considerations that I was referring to were the fact that we were removing a no carbon emitting resource, and so that we replaced it with non-carbon emitting resources. The RPS requirements were already met in 2022 with previous resources on the system. These resources were not contributing to the RPS requirements in 2022, 2023, 2024.
But yet they are being banked for your RPS compliance in 2025, is that correct?
They are being banked for future use. It's not entirely clear whether it would be 2025 or some other year, but they will provide a benefit to the system by deferring the need for potential future procurements because we are allowed to bank RECs on behalf of our customers.
So is PNM's position that you only have to ask for an RPS resource in an RPS case if you need those RECs in that year? Like there's no forward-looking.
As I stated in my rebuttal testimony, there are a number of reasons why we have proposed the categorization the way that we have. This procurement, as was described throughout the entirety of that testimony, was done to replace the leased energy coming from the Palo Verde nuclear generating station, as well as to increase reserves and maintain reliable electric service for our customers. This was done for the system use of our customers and to maintain the system resource adequacy requirements. There are other benefits that come from this procurement, such as the generation of renewable energy certificates that could also be used to meet RPS requirements in the future and add to the bank, but that was not the primary consideration of this procurement.
Is it PNM's position that those added benefits have a $0 compliance cost?
As I've mentioned before, I think that this should be re-examined in a rulemaking, and there might be need to look at the differentiation in the way you would do the RPS calculation in total. I think if we are to take the proposition of doing everything that's renewable related and putting it into the RPS for recovery there, when we get to a system that is 80% renewable, voluntary customers would be heavily subsidized by non-voluntary customers if they are not paying for the energy that's associated with charging batteries, discharging those batteries, and that's not being used when their resources are not necessarily balancing their loads and resources in real time. So I think that this needs to be done in a holistic fashion.
Have you done that analysis that voluntary program participants would be heavily subsidized? Have you done that analysis?
That is my.
Or is that just your thought?
That is my thought.
Okay, and the question that I asked was not about 80%. The question that I asked was whether it was PNM's position that there was a $0 compliance value for these RPS resources, and I believe your answer was no. That you believe we all need to reevaluate that.
My answer was that we do need to reevaluate it. The compliance mechanism, there is definitely a very, very small cost associated with retiring RECs through Regis when those RECs are retired. There's no cost to maintaining the bank. Now, because of the bundled REC and energy requirement, if a resource is added as a part of a low-cost procurement system resource, in my mind, it is a benefit of getting the RECs that would defer future RPS procurements. I think that this is something that should be vetted out more fully in a rulemaking, and we need to look at that going forward. I do not believe that right now there is anything incorrect with the way that we are doing it.
I just wanted to ask you a question about something you said. You said that the portfolio, well, let me have a foundation question first. In the IRP, which you're in charge of, is that accurate?
Yes, I am.
There were two paths laid out in the IRP. There was a technology neutral path and a no new combustion path. Is that correct?
That's correct.
In one of the answers that you just gave me, you said that the replacement portfolio and the reliability package in 21-00215 was the lowest cost portfolio. That's not accurate. Is that correct?
I believe you've misstated what I had said. I said that it was the lowest cost portfolio subject to the policy considerations, and subject to those policy considerations, my answer is accurate.
And you said that the policy considerations are not the REA requirements?
Mr. Hearing Examiner.
Yeah.
Okay, sorry, I'll move on.
Stop.
My question.
Let's hear the objection first.
I'd like to object on grounds that for the last 10 minutes or so, we haven't heard any question tying the substance of this dialogue into this particular application. Ms. Gould's own witness suggests that the classification of resources be held elsewhere. So let's do that. My objection again is on relevancy grounds.
Hey, stop, Ms. Gould, don't speak over the person speaking. Wait till I call on you.
And
Go
also,
ahead, Mr.
Thank you, Mr. Hearing Examiner. Also, that we're deviating significantly from the issues that are material in this application.
Go ahead, Ms. Gould.
Mr. Aikenhead is mischaracterizing my witness's testimony. I think I've already discussed why this is an issue in this case. I think that while it could be addressed in the rulemaking, we have no idea what the commission is going to decide, and that it is Anna Maria's right to also discuss it in this case because it is relevant and PNM has brought it forth, and PNM is using these RECs as banked RECs. And I think that I have tied my questioning to this case because I'm specifically asking Mr. Phillips why PNM has chosen why PNM chose to ask for a Trisco in this docket, in the 215 docket, and not in an RPS docket. I have a few more questions on this, but I would like some clarification because my understanding of Mr. Phillips' testimony is he said the resources in the 215 docket were the lowest cost portfolio, and I'd like to probe that just slightly.
So Ms. Gould, I mean, I understand where you're going with all this, but what I'm listening to this, Mr. Phillips, is repeating himself, and I'm not inferring anything from that. I'm thinking he's giving you the answers that he's going to give you. So to the extent to which you have briefing opportunities in this case, you're going to have them. And Mr. Phillips is here at the present moment not to have a argument necessarily about policy, because that will be the commission's determination as to what policy it thinks most advantageous. If you have additional fact questions for Mr. Phillips, let's hear them. And I think at this point we should just try to move on the best we can.
Well, I would like to ask Mr. Phillips why he asks for resources, why PNM asks for resources in one case and another. It goes directly to how PNM has presented its RPS case. What Anna Maria is trying to understand is what are the factors that PNM is using to categorize. And since PNM says, well, in 195 we were approved this, and in 215 we were approved that, we're trying to figure out how PNM determines where to ask for these resources and which dockets.
Okay, so I'll just do this and see where this leads us. I mean, if I understand the testimony presented by Mr. Meyer, Mr. Phillips, his argument is that it's arbitrary, and I presume PNM's position is very much that it is not arbitrary. So, Mr. Phillips, can you just answer the question as to what guides PNM when it is considering whether or not to consider these new renewable projects we've all been dealing with under RPS or some other different mechanism for cost recovery?
Sure, and allow me to provide maybe a bit of context as well. So it used to be that renewable procurements were more expensive typically than other procurements. And as time has progressed, especially in the recent terms, setting aside the recent price spike due to the supply chain impacts, renewable resources have gotten to the point where they compete dollar for dollar with other resources. The RPS rider, when we would put something in the RPS rider previously, it was typically because something special was done to procure those resources, and rather than doing just like a normal system procurement. In the 19-00195 docket and in the 21-00215 docket, the portfolios that were developed were system portfolios to replace capacity and energy from the coal plant and the nuclear generating station that were being retired or returned. And those portfolios were developed not for specific compliance with the RPS, but to serve broad system needs. We asked for those resources in those filings commensurate with that approach. PNM is open to a rulemaking and a discussion on whether we need to look at this differently. I do not think that looking at this in a way where we say the entire cost of a resource is either renewable or is system is appropriate. And I definitely would not be okay with saying anything renewable right now should go to the RPS rider as a binary approach. There might be a way where you would look at and say, what's our system cost? And any premium over that to get renewables should go into RPS. There might be something where we look at pro rata allocations of renewable resources relative to the RECs needed to be retired that year in order to do RPS compliance. But doing a binary separation of the resources into these two buckets and then pushing them all into a category where certain customers do not pay for any of those costs could end up leading to a cross subsidy as these amount of resources are increasingly being used for system needs. And so that's my concern. Going about it right now without having a holistic approach could lead to detrimental impacts across the system.
And so I just want to ask a follow-up question, and I'll get back to Ms. Gould in a second, but it's probably Mr. Gutierrez says in this case, in his testimony, and I believe it's Mr. Gutierrez, if I'm wrong, then whatever, you can correct me, but he says there's a benefit to riders in that depreciation is reflected in the rider itself in a rapid fashion, right? Whereas I think, if I understand correctly, the point would be if we did this through base rates, you'd have to wait to a rate case, and there's sort of this lag that's there. And so that's got to be part of this sort of more strategic thinking in terms of PNM's business model that's factoring into that consideration. Am I correct to say that?
The rider would reset itself each year to reflect the decreasing revenue requirement for utility-owned resources, including depreciation over time. For those renewable resources that are owned by a third party that we pay for on a unit of energy delivered basis, that would not matter whether it's in the rider or the fuel clause in terms of reflecting depreciation.
I guess more generally, I'm trying to, as Ms. Gould's sitting here suggesting, I think the argument for Mr. Meyer, like there's no way to break out why PNM's doing it through the RPS or doing it through some other mechanism. I mean, it seems, each one of those price mechanism or price recoupment mechanisms have benefits inherent in them, and that's part of the dialogue. I mean, is that basically correct?
That's basically correct. And insofar as the cost recovery to P&M is done through one of those mechanisms and P&M's made whole, I think that we are okay there from the P&M perspective. The concern I would have is, if you have a distinction between a rider or a cost recovery component that is paid for by some customers but not for others, you need to do a very holistic view and make sure that whatever way you categorize these pieces, it's not leading to disparate treatment. I do not believe that what's going on today is leading to disparate treatment. I believe that the proposal that is in this plan is valid, but we are open to discussing further considerations and doing it in a holistic fashion to get input from other parties and to make sure that it's done across the New Mexico footprint and other utilities in a fair and unbiased way as well.
Okay.
That's why I think the rulemaking is appropriate.
Yeah, no, I understand that. And so, Ms. Gould, I think, I'm not trying to ask questions for you, but I'm just simply saying, I don't know if we're going to get a whole lot more from Mr. Phillips beyond what he's just said.
Yes, and I understand P&M's position, but it's just hard for me to rectify, what I just heard. Part of his explanation was, the costs. They used to be more expensive, but some of the renewables in the rider are the lowest cost resources on P&M's system. And so I'd like to bring that out. I think it's important when we have these conversations, wherever they happen in the rulemaking or in the next case, that the commission is aware of how P&M is treating these resources. And if P&M says that full categorization of these costs would produce, what did they say, subsidies, well, using $0 would also create subsidies too then, right? You can't have one without the other. So if not counting these costs and not crediting voluntary program participants, equally create subsidies, right? So I think that's the point.
I understand, but I guess what I'm trying to suggest to you is that you're here to question Mr. Phillips about this particular case. And, he's given you the answer, and to the extent to which there's other documents out there that you want to, show to him and say, hey, well, that's inconsistent. That's one thing, but then the broader policy discussion can happen in the appropriate venue, which would be briefing in this case.
Okay. So I do have a couple more. I have more questions, and they might not be. Mr. Phillips might not be able to answer them. He might have to direct me to other witnesses. Hold on. Okay, so my understanding of P&M's testimony is that without the resources that I'm questioning you about, the 195 resources and the 215 resources, P&M still meets its 2023 plan. Is that correct? Its compliance, its RPS compliance?
P&M's testimony, and this was put into my responses to Mr. Hearing Examiner's bench request, shows that absent the recs that are expected to be generated from the resources approved in case number 19-00195 UT and case number 21-00215 UT, P&M still expects not only to maintain compliance, but to add recs to the bank as well in 2023 and 2024.
Do you know if when into 2025, when the RPS increases to 40%, if P&M will meet its RPS target with the renewable resources that you have accounted for in this plan, or if P&M will have to acquire additional resources?
I'm sorry, can you repeat the question?
In 2025, when the RPS increases to 40%, will you meet the RPS target with the renewable resources you have accounted for in this plan, or will you need to acquire additional resources?
When you say the renewable resources accounted for in this plan, are you referring to only those resources absent the San Juan and Palo Verde replacements, or are you talking about all resources?
I'm including the 195 and the 215 resources in that question.
I don't know specifically. We have not done the 2025 informational filing. That will be done next year, and then the actual 2025 plan will be filed in 2024. We do know that through the documentation we've been giving to the commission that there's a number of things that could be changing around. We expect to be able to meet the 2025 RPS. We have no doubts about that. It'll be a combination of these resources, maybe other resources, as well as potentially use of the bank.
When you mean these resources as well as other resources, do you mean that PNM may ask for additional resources to meet the 40%?
I believe what I've laid out, and let me find it in my testimony here. But I believe what I've laid out is that, there will be a combination of the resources that are included in Mr. Gutierrez's table. Some of those resources are still pending, whether they will actually come to fruition or not. So there may be other resources that are asked for, maybe not. We are still running through the evaluation of outstanding RFPs. I'm trying to find the question that Mr. Hearing Examiner asked me so I can at least be consistent with what I've said there. So in his first question is what is the status of the most recent RFPs, and is PNM presently planning to use projects selected from that process for purposes in 2025? And I discussed there the RFPs that we're still evaluating them, and the compliance for 2025, we fully intend to comply. It'll be a combination of resources that we have obtained approval for or are already on the system, and it could potentially include, though we are not sure yet, additional resources that would be part of a system procurement to replace some of the previously approved capacity and energy from resources that have either delayed or defaulted on their performance.
Would it be fair to say that PNM would not meet its RPS requirement in 2025 without the bank directs from the quote unquote system resources?
I don't think that would be fair to say. We don't know exactly yet because we're still going through the analysis and the procurement timeframes.
Do you know how PNM accounts for bank directs? Like how it monetarily accounts for bank directs?
Monetarily, can you please explain?
So let me give you a hypothetical to ask my question, if it makes more sense. If there's what PNM has been calling an RPS resource that costs $100,000, and in 2023 it produces 100 RECs, but you do not need those RECs in 2023, so you bank those RECs for future use. How do you recover the $100,000? Do you put the $100,000 in the RPS revenue requirement the year the RECs are produced and banked, or do you create a regulatory asset and recover the $100,000 in the year the RECs are retired?
So let me make sure I understand your hypothetical. The hypothetical assumes first that the resource in question has been included in the RPS requirement. We're not categorizing it as a system resource. That's the first thing I want to make sure of. Yes.
Yes.
So in that instance, the revenue requirement for the year that the RECs are produced is what is recovered through the RPS rider. The banking is a mechanism where we can use those RECs later on. The RECs would still be valid for, I believe, up to 4 years, and there might be instances where a REC, there could be, if we take the hypothetical a bit further and say, what if we have enough renewable resources on our system to produce, say, 40% of system needs when the RPS is only 20%, so essentially double what we would need. Could be that there would be a year where we use no RECs that are generated that year for RPS compliance, because we would want to retire the RECs that are the oldest to make sure we don't lose the ability to use those RECs in the future. So, the answer to your question is that we would recover at the time both the energy and the REC are delivered to our system we recover that amount of dollars in that year through the RPS rider if it's an RPS resource. And then the RECs could be used later for compliance. And there's no cost to carrying those RECs. There is a very minor cost when those RECs are retired through the Regis fees.
Okay, so if I understand your answer correctly, if the Hickory Solar PPA and the Arroyo Solar PPA, the two PPAs that were approved in 195, if those were considered RPS, quote, RPS resources, then the cost of those PPAs would be included in 2023 in the revenue requirement for 2023. Is that correct?
In the hypothetical, yes, but those are not RPS specific resources. Those were a part of a system resource procurement and have been categorized as system resources. So the hypothetical is not valid.
I'm just trying to figure out how PNM recovers for its bank directs. And what I'm hearing you say is that they recover at the time that the recs are generated, and then the bank is kind of free, like when they retire the bank. Well, I guess there's a small cost, like 8.8 cents or something. Is that correct?
Could you repeat the question, please?
PNM, I was just trying to figure out how PNM accounts for its bank directs, and what I heard you say is that it recovers the costs associated with the energy and the RECs at the time the RECs are produced.
Whether it's recovered through
If it's
or,
a system, if it's a RPS, quote, RPS resource.
whether the resource is a system resource or an RPS resource, the costs for that, assuming it's a renewable PPA, are recovered through the fuel clause or the RPS rider at the time the energy is delivered.
Okay.
If it's a renewable resource and going to be eligible to use to compliance with the RPS, the REC must be delivered with the energy. We can then bank that REC for future use, but we're really recovering the costs of these resources commensurate with when the energy is delivered.
And that's probably, just to interject and to clarify, the REC itself is a product of generation, right?
Correct. There is no REC without the energy.
Right.
I believe that's all my questions, but if I could just take a minute to look at my notes.
Sure.
Okay, that's all I have. Thank you so much, Mr. Phillips, for your time. And Mr. Phillips answered all the questions I also had for Mr. Gutierrez and Mr. Baker. So that is all the cross I have for today, Mr. Hearing Examiner.
Thank you, Ms. Gould. Mr. Herman, anything?
No, Mr. Examiner.
Ms. Lynch, CCE, anything? Questions?
No, sir.
Is Mr. Albright still with us? He is not. I do not believe so. Mr. Borman.
Thank you. I do have a few questions. Should be fairly brief. Good morning, Mr. Phillips.
Morning, Mr. Borman. Good to see you.
Good seeing you too. So this is kind of in response to the very beginning of your testimony when your attorney was moving your exhibits into the record, and I think asking if you had any changes. And in response to questions from your council regarding such changes. I think you identified or you stated that some projects have shifted back. Do you recall that discussion?
Yes, sir, I do.
Okay. Now, I believe you mean when the projects have shifted back that there are some projects that have been delayed. Is that correct?
Yes, sir, that's correct. There was 2 projects that were, we, at the time of filing, we had anticipated them being online earlier, and then in subsequent compliance filings, we had notified the commission that those commercial online dates have slipped back a little bit. Those 2 projects are the Arroyo project and the Hickory project that were both approved in the 195 docket.
Okay. Arroyo and Hickory.
Yes,
And
sir.
are those changes, delays, if you will, reflected in your response to the bench requests that the hearing examiner had served on you guys?
Yes, sir, they are.
Okay. And I think you also said in this discussion with your attorney that these would have no impact on compliance. Do you recall that?
Yes, I do. They would not impact our forecasted ability to comply with the 2023 or 2024 requirements.
Okay. That was actually my next question, but I'll move on. And you say that they would have no impact on compliance in 2023 or 2024. Would they impact the amount of RECs that you would be able to bank in 2023 or 2024?
Yes, they would. Any output from those facilities, we would have anticipated banking in 2023 and 2024 for use in the future. So it would reduce the amount of RECs we would otherwise bank.
Okay. Do you know how much of an impact on the number of RECs that you would be able to bank that would be?
Just from the delay you're speaking of?
Yes.
I don't have that at the top of my hand. We could probably come up with something. I don't think it's that much.
Okay, well, if you don't know, you don't know, and I'm not gonna belabor the issue, but
Mr. Borman, hold on a second. So Mr. Phillips did just say that he could provide it to us. So why don't we have the first sort of in-hearing bench request goes to Ms. Sanchez, and we'll provide the second one to Mr. Phillips, and he can supply us with what it is that you would like to see. That sounds satisfactory?
certainly to me.
To us too. The hearing examiners as well would like to see this. So Mr. Phillips, do you need Mr. Borman to clarify what it is we'd like to get from you?
Let me just ask him to make sure I understand it correctly.
Sure.
So, and do you want this by project or just in total would be my first question. And effectively, you would like to know how many RECs we are anticipating those projects to produce, based on the time we filed versus how many RECs we would expect those facilities produce as of our most recent compliance filing. The difference would be, what we don't believe would be added to the bank.
I think that's correct. I think it would be helpful to have them by project. I mean, there's only 2 projects that we're talking about here, right? So, and it would be helpful to have that broken down as what you initially projected, what the amount of RECs that would initially projected to be created, and then the amount that would be created in the updated, I guess, I don't want to call it forecast, but the updated plan.
Certainly.
And Mr. Borman, just for clarification, if I understood correctly, you sort of started this inquiry with banking, right? That's what we were talking about.
Yeah, but I think it should give us the amount that they're going to bank, because if they were creating
right
500,000, I don't know, 1,000 RECs, that was their initial proposal, and planning to bank 500 of them. Well, if they're only going to create 500 RECs, then they won't be able to bank any of those, presumably, right?
Yes, and I presume the question too, I mean, the macro level thing that you're asking about is where are we going to be in 2025, right?
Yeah, exactly. That's really where we're trying to get at.
And Mr. Phillips, is that clear? Does that make sense?
That's clear. And yes, that's clear. This will only affect 2023. These projects are not expected to delay beyond even the summer of 23. They're expected to come on in April and May respectively. So the change would be relative to 2023 bank.
Okay, 2023 and basically Q1 of 2024, right? Or excuse me, 2020, wait. Oh, now my head is all screwed up. So if it's not till April, you'll have the first 3 months of that, right?
Correct. The
right.
projects would be delayed by, would not be producing RECs in the first 3 or 4 months, depending on project of 2023. And so those banks that were otherwise expected to be generated when we first filed the application would no longer be generated and added to the bank.
Got it.
We can provide that update.
Great.
Thank
Mr. Aikenhead, you'll see that Mr. Phillips's response is filed on eDocket. You can just submit it all as bench request 1, bench request 2, just one document. Does that make sense?
Sure. Yes, no
Thank you.
problem.
Thank you. That's all that I have for questions.
Very good. Thank you, Ms. Borman. Ms. Anaya Allen, would you like to go first, or do you want me to, or what would you prefer? I think she might be muted.
I do have a question about the racks.
Sure, go ahead.
So, Mr. Phillips, are you familiar with PNM's proposal with respect to retiring the REC program for individual solar customers that has been proposed in Ms. Sanchez's testimony?
I'm generally aware of it, yes.
Are those RECs included in your analysis in terms of how many RECs might be banked or are available for use by PNM?
Allow me to go to Mr. Gutierrez's exhibit. I will say I believe they are. I just want to double check. Prior to, and a little bit of history, prior to the Energy Transition Act, there was a requirement to have, a diversity portion where these RECs would be fulfilling that requirement. That no longer exists. But like I said, let me find Mr. Gutierrez's table here. And I guess I would say let's double check with Mr. Gutierrez when he's on the stand. But if I go to his PNM exhibit SG-2, I believe the line item 8 and line item 9 are representing those RECs that were purchased from the programs that you're referring to. But let's double check with Mr. Gutierrez.
Yeah, I'll do that. So do you know, and I will ask Mr. Gutierrez about that further. Do you know whether or not those RECs are included in retirement of those RECs is included in the analysis that PNM has done in terms of what it will have available in its bank?
Though those RECs would be included either in compliance by retiring them this year or included in the bank. Really everything gets put into a big pot, in terms of what's generated that year. Some of it gets retired, some of it gets put in the bank. And typically it's the RECs that are oldest in vintage that would be retired first, because at some point in time you can't use them anymore. So you want to use them before you lose them. What I can say is the amount of RECs generated by the small and large distributed resources are very, very small and minimally contribute towards RPS requirements.
Okay. So the retirement would not affect PNM's ability to meet its 20% requirement for 23 and 24?
Correct. Not in a material way. If we didn't have those coming in, we would be in the same, effectively the same position where we would be able to comply in 23 and 24, even without those.
Thank you.
Yes, ma'am.
Hearing examiner Anaya Allen, anything further, or do you want me to, I can ask my questions?
No, I have nothing further from Mr. Phillips. Thank you again.
Sure. So, Mr. Phillips, at your direct testimony at page 9, you're sort of talking about the disruptions and the delays in the projects, and you say there at pit lines 13 to 15 that you directed Mr. Gutierrez to use conservative expectations. And I was wondering if you could clarify, like, when you were directing him to do this, what does that mean?
So when we go through a contracting process and a procurement process, there's two different dates that are associated with the delivery of projects. There's an expected commercial online date, and then there's a guaranteed start date. And in between that time period, if a developer were to miss the expected commercial online date, liquidated damages provisions would kick in until the project comes online. If it does not come online until prior to the guaranteed start date, then that project would be in default. And that's a simplistic representation of how the contracts work, but good enough for the purposes right here. For some of the projects that we just were really uncertain of, and didn't have enough confidence in some of the developers because they were through negotiations not wanting to commit much in the way of liquidated damages or other such things, we would put in the guaranteed start date in our calculations for the expected rec production as opposed to the expected start date. So a difference of 6 months of timing and the associated energy and rec production with that associated timing.
Okay, that's useful. Thank you. And this is sort of slightly different question, but I did see the compliance notice that there is a plan to double the size of the battery storage at Atrisco. And I just maybe was wondering right before this proceeding, for REC's purposes, the solar generation is the only thing that produces a REC, right? The batteries don't have any consequence, I suppose. That's right, correct?
That's correct. The REC production is measured at the output of the solar facility, regardless if it's delivered to the system at that time or put into a storage system and delivered to the system later.
Yeah, so the batteries, they're basically non-contributors. I mean, they're doing something very useful, but not for purposes of RPS.
Correct.
Yeah, okay. Just wanted to clarify. So at page 11 of your direct testimony there, the response you give to the question beginning at line 13 in the bottom, if I'm not mistaken, that answer also appears in a footnote in one of your exhibits. Is that right?
Yes, sir, that's correct. In P&M exhibit NLP2, which is the RPS plan document itself, it appears as a footnote at the last page.
So tell me, just explain to me, and perhaps in whatever words you want to do now, why are you saying this?
In my mind, there's a misconception that all resources are equal, or we should be comparing resources on just $1 per megawatt hour basis when different resources have different attributes. So if I think about a renewable resource such as solar or wind, those are not as good at providing reliable capacity when I need them to serve my customers. And so looking at that on $1 per megawatt hour basis versus, say, a peaking gas CT or even an energy storage resource is kind of inappropriate in terms of the way we can dispatch those resources and count on them. Even further, a battery, for example, without an associated resource it can store energy from, it's kind of useless. So there is no $1 per megawatt hour cost for a storage resource in my mind, because the value of that is about taking energy that's on your system and moving it to and discharging at a different point in time. So we just want to make sure that when folks are thinking about the idea of levelized cost, that you keep in mind that if you want to compare, say, two solar PPAs, that's a valid comparison. If you want to compare a solar PPA to an energy storage resource or a wind farm to a natural gas resource on $1 per megawatt hour basis, those types of comparisons are more meaningless.
Okay, and thank you for saying all that, because when I was reading this and I was thinking back to the 21-15 case and all the discussions we had about levelized cost of energy, and that's what this is about ultimately.
Yes, sir.
Yeah. Okay. Okay, that's the direct testimony. Let's go to the rebuttal here. Nothing for that. And now let me just look at the answer. Oh, at your supplemental testimony, Mr. Phillips, and I just maybe I'm confused, but beginning at page 1, on the bottom there at line 21, you're talking about the 2 active RFPs, right? And then you clarify these RFPs are the 21 RFP, which was issued in March of 21, and would require projects to be online no later than May 31, 25. And then there's the 23, 24 RFP, which was issued, later, or 5. Oh no, maybe it is not later. And that, well, in any case, the sentence goes on, that would require the project to be online no later than May 31, 23 or May 31, 24. And I was reading that and I was like, wait a minute, is the earlier RFP have a later start date?
It did. The 2021 RFP, and I do recognize that there is a lot of confusion with the naming convention sometimes with our RFPs. The 2021 RFP was issued right around when we filed our abandonment application for the Four Corners 200 megawatts. And it was anticipated that we would be using that to replace the capacity and energy from the Four Corners plant if the abandonment had been approved. As we move forward in time and more things became uncertain about previous resources that have been approved actually being able to meet their online dates, we issued a subsequent RFP titled the 2023-2024 RFP to determine if there was anything that we could try to bring online sooner to help fulfill the needs created by the defaulting or delaying resources.
Okay, that clarifies that. Thank you. And then just for clarity, Mr. Borman asked a good question. Page 3 of your direct testimony, or sorry, the supplemental. That beginning of line 13. And it says, based on the information in PNM's most recent compliance notice. Is it possible for you to tell me what is PNM's most recent compliance notice? There's so many.
Yes, sir. So we have to file compliance notices in the 19195 docket / the 20182 docket at the end of every month.
Okay.
And then there's a separate compliance filing we have to make every other month, I believe on the 16th of each month in the 21215 docket.
Right.
The most recent filing I believe we've made was the August 31st filing in the 19195 / 20-182 dockets, though the commission recently appended those to be directed more towards 2023-2024 requirements, as at least like the L&R tables and things like that, as opposed to just 2022. But that was our most recent filing, is the end of August.
Okay, and then would I be correct that the notice that you all just provided in 215 about doubling the battery at a Trisco, that's not really the compliance notice, kind of what you're talking about, just the moment you just spoke, right?
That's correct. That amendment notice was made, subject to the 10-day provision for review and then potential protest by parties. Otherwise, it would be deemed approved. Assuming that there are no protests, we would include that additional capacity in a subsequent compliance filing.
Very good. Yeah, just good to have clear, like, which filing we're talking about. It's a good. Just one last question, I think. I have to just look at your NLP2. It's in the application. Bear with me. This is relating to the Hickory solar one. So I asked you some questions in the requests, the bench requests about the Hickory project. You correctly pointed out that I had gotten that wrong. I transposed numbers. I just reproduced I think it was the other. I think it was Arroyo or the San Juan, and it's 137,777 should be the number for the Hickory will generate in 2023, right?
That was what was expected at the time we filed. That expected online date is one of the two that have been pushed back. So when we provide the information in the bench request for those two projects, that number will be updated.
So do you have an expected output for the Hickory at this point?
I mean, a approximate number would be 2/3 of that 137 number, but we'll get the exact number.
Was it in the context of responding to Mr. Borman?
Yes, sir.
Very good. That's it for me. Any redirect for P&M?
None. No, thank you.
Any questioning based on my questions with Mr. Phillips or Ms. Anaya Allen's questions for Mr. Phillips?
None from me, thank you.
No, thank you.
Hearing examiner Anaya Allen, do you have any further questions for Mr. Phillips?
No, I do not, thank you.
Very good. Okay, Mr. Phillips, thank you very much, sir.
Thank you, sir.
Take care.
Bye.
Would we be next moving to Mr. Gutierrez?
Yes, that's correct.
Can I ask the parties, is there anticipation for questioning? I know Ms. Gould said no at this point. Is anyone else going to have any questions?
I have little to none.
Okay, so then my thought is I'm asking only because it's 11:39. Why don't we do Mr. Gutierrez and then break for lunch? Is this acceptable to everyone?
Yes.
Yes.
Mr. Lee, you're the most important person in the room. Is that okay?
Yes, sir.
Do you need any break before we go to Mr. Gutierrez, Mr. Lee?
No, sir.
Very good. All right, Mr. Aikenhead.
Great, thank you, Mr. Hearing Examiner. PNM now calls Mr. Gutierrez, Shane Gutierrez, to the witness stand.
And Mr. Lee, if you could swear him in.
Thank you. It may take him just a moment to get situated.
Yeah, right. No, we gotta.
Mr. Hearing Examiner, Madam Hearing Examiner, this is Kelly Gould, if I may, while we're waiting. I am having an unstable internet connection and just got kicked off, and so I am not currently appearing by video. I just wanted to make that known.
Thank you.
Hopefully it'll resolve as the afternoon continues. Thank you.
Yeah, it's one of the limitations on Zoom. Is it like the infrastructure has to work or it all falls apart? All right, Mr. Lee, please swear in Mr. Gutierrez.
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the whole truth, nothing but the truth?
I do.
Thank you, sir.
Great. Good afternoon, Mr. Gutierrez. Will you please state your full name for the record and your position with PNM?
Yes, my name is Shane Gutierrez, and I'm a senior project manager in the Integrated Resource Planning Group at PNM.
Thank you. And do you have a copy of your pre-filed testimony before you in this case?
Yes, I do.
Just to be clear on the exhibit numbers, it should be what's been pre-marked PNM exhibit number 5 and pre-marked PNM exhibit number 6. Does that look right?
Yes.
Great. Let's start with what we've marked as PNM exhibit number 5, your direct testimony in the case. Was that testimony prepared by you or at your direction?
Yes, it was.
Are there any errors in your testimony that need to be corrected here on the stand?
I just have a few corrections.
Go ahead and take us through those.
My direct testimony. So I have a correction on page 9, line 15. currently shows in my direct testimony become operational by June 2024. That should say December 2024.
And just so the record's clear, you're on page 9, line 15, correct?
Right.
And Mr. Aikenhead, is this reflected in what was shared on Dropbox, or is this not?
Now, this is not reflected in the exhibits that were uploaded. There's just a typographical error in these references to June rather than December.
Okay, and again, I'm looking at Mr. Gutierrez's testimony uploaded to Dropbox. I'm at page 9. You said it was line, which, Mr. Gutierrez?
It's line 15.
I expect, okay, so that line 15 should read energy facility that energy facility 1 that is expected to become operational by June 24, and you're saying it should be July 24.
It should actually say December 24.
Oh, excuse me, December.
Yes.
Okay.
That's the first correction. And then the second correction was, it's a similar one. It's on line 20 on the same page. Replace June 2024 with December 2024.
Thank you. I just want to make sure the record, it reflects those two changes. The second change was line 20, page 9. It should read December of 2024.
That's correct.
Taking those corrections into account, if I ask you the same questions today, would the answers to your testimony be the same?
Yes, they would, with the clarification, accordingly what Mr. Phillips mentioned previously, there have been some project delays, but other than that clarification, everything is true and correct.
And that was my next question. Taking that into account, is your testimony true and accurate to the best of your knowledge?
It is.
All right. Thank you, Mr. Gutierrez. I'll go ahead and move the admission of what's been pre-marked as P&M Exhibit 5.
My only thought as I'm thinking here, Mr. Aikenhead, is that for purposes of ensuring that the testimony reflects, the concept with the Dropbox upload is, and this might have just been that Mr. Gutierrez figured this out at the last minute. That's fine. These things happen all the times. But what I'm thinking we should probably do is have you submit just as an email to the service list an updated version of this exhibit with those corrections that Mr. Lee will then make part of our official transcript. Is that okay?
Absolutely. Yeah, that makes sense.
And Ms. Lee?
I have a question.
Sure, go ahead, Ms. Allen.
Thank you. Mr. Gutierrez, on line 17 and on line 22 on page 9 of your direct testimony, it indicates that there's projected energy production for 2024. Since you've now changed the dates on which these facilities may become operational, would that then affect this projected energy production?
No, it would not. Actually, I'm changing the months there to align with the estimates that I do have in my direct testimony and my exhibits.
So even though there would only be then, 1 month of energy production from these facilities, you would still, that would be the projected energy production for 1 month?
That's correct.
So
At least for December of that year.
So this would be December 1st, the operational date then?
That's what I assumed. That's correct.
Thank you.
All right, so Mr. Aikenhead, why don't you just go ahead and submit afterwards? You'll have the opportunity to change those over, and then I will provide it to Mr. Lee as Exhibit 5. Okay.
Yes, that sounds fine. We can do that. I don't believe there are any other objections, but I'll just formally move the admission of P&M Exhibit 5 just to make sure we have a clear record.
Sure, yeah. And are there any objections to the admission of this exhibit? I don't hear any, so we'll admit Exhibit 5 with the proviso that a new version of it with those two corrections will be submitted And that'll make the record clear.
Perfect. Thank you, Mr. Hearing Examiner. Mr. Gutierrez, do you also have what's been pre-marked P&M Exhibit 6 before you?
I do.
Well, so wait, Mr. Aikenhead, before you do that, let me see. Are you going to admit Mr. as a P&M exhibit? Because that would be inconsistent with what we've been doing so far.
You're right, Mr. Hearing Examiner. I apologize. This is not rebuttal, it's supplemental. So I'll stay consistent and allow you to admit that as a commission exhibit.
Hold on just 1 second. I have to mute myself for 1 second. That was our IT department making sure our internet connection is stable. So sorry. Yeah. So thank you, Mr. Aikenhead. I think it's good to keep this consistent. So, Mr. Gutierrez, you recall I asked some bench requests circulated on August 23, 2022, and you recall making some supplemental testimony in response to those?
Yes, I do.
And that supplemental testimony was originally designated as P&M Exhibit 6. Is that right?
That's right.
And then if I ask you those questions and you were here today, would you, if I were to ask them to you now, would you answer them in the same fashion you have in the pre-filed testimony?
Yes.
And that testimony is true and correct to the best of your knowledge?
Yes.
Great. So in that case, what was formerly P&M Exhibit 6 will be marked as Commission Exhibit 3. And that is the supplemental testimony in response to bench request of August 23, 2022 of Shane Gutierrez. Any objections to admission of this? I don't hear any, so that will be admitted. Anything further, Mr. Aikenhead?
No, thank you, Mr. Hearing Examiner. Nothing further for now.
Great. Ms. Gould? Nothing further, I assume, still.
No, thank you.
Well, let's just ask this way. Anyone else besides Mr. Borman?
No.
Great. Mr. Borman?
Mr. Borman has no questions for Mr. Gutierrez.
Okay. Mr. Gutierrez, I have one question. It's actually a very simple one. I was sitting here reading your testimony and wondering to myself, this is your direct testimony. This is a very general question. Your projected retail sales, how does P&M project its retail sales?
I received those projections from the P&M load forecasting group, and they, my understanding is they work with an outside consultant along with the load forecasting group to come up with forecasted energy and energy sales and demands for P&M system. And so
Okay.
I utilized that forecast to populate my exhibit and my testimony.
And all right, so you're relying on the not testimony, but you're relying on the data supplied by that group. If you don't know the answer to this, there are a couple other additional questions. It's fine. I'm just wondering, as those projections are coming out, I mean, we're expecting, transportation electrification, the potentiality for more electrification of buildings. To what extent gas will continue to play a role in, our daily lives. Who knows? So to the best of your knowledge, is all that built into those projections?
My understanding is, and working with their consultant on coming up with a forecast, an energy sales forecast, they're accounting for those dynamics for our system as time goes forward. So, those types of impacts to our sales should be accounted for in this energy forecast in my testimony and exhibits.
do you know, as you're kind of working through these cases, because, I saw you last year and now we're here again, did the projections line up with what ends up happening as far as you're aware? Or are you not sure?
That's a good question. I think in general, they have lined up pretty well. But that's kind of offhand, I kind of may have seen some numbers in terms of comparisons, but I don't have any specific documents that I can refer to or that I can recall it. I've actually studied or evaluated. So.
Okay. That was all the questions I had, I believe.
Mr. Hearing Examiner, I know that you, or actually Mr. Borman brought it up regarding the number of RECs.
Oh, yes.
Would change according to the updated in-service dates for Jicarilla and Arroyo.
Okay.
Yeah, I can give you my calculation of those. I did those prior to this hearing, so I can provide those if those would help.
Sure, and I think
maybe
still...
a bench request, or maybe just talk about those right now.
Yeah, no, and that's what we can do it now, but I'd still like to have it in the bench request just so that it's provided for the record. But if you have the numbers, you can say them.
And so for my calculations, and just to give a little context, so the 50 megawatt Jicarilla project, initially I assumed an in-service date of November 1st, 2022. And that is reflected in my SG2. So that you're getting around 138,000 megawatt hours in 2023. So a full year of production. Per our July compliance filing, obviously that date has shifted out to April 1st. And so all that would do is it would impact the amount of banked RECs we could use or put into the bank for 2023. And that the impact of that is it would be a reduction of about 28,000 RECs from that facility due to the shifted in-service date.
Okay.
So the new estimate is like around 110,000 RECs for 2023 from that facility, as I sit here today with assuming the July compliance filing date.
Okay.
And then lastly, the Arroyo Solar, I assumed a staggered kind of in-service date. So we assumed that 150 megawatts would be installed by November of 2022, and the remaining 150 megawatts would be installed by February of 2023. That assumption, gives you about 811,000 megawatt hours of production for 2023. With the updated estimate with the update from the July compliance filing, that's been shifted out about 3 months. So now I'm assuming a February in-service date for the first 150 and a May in-service date for the remaining 150 megawatts. And that results in a 2023 production number of about 684,000 RECs or megawatt hour RECs. And the impact of that facility being delayed is about 127,000 megawatt hours less RECs that would be put into the bank. And so the combination of those two projects, it's about 154,000 RECs less that we'd be able to put into the bank for 2023, which is it's a pretty small number compared to the total estimate of bank RECs that we're projecting for 2023. So a minimal impact.
Okay, and I would like, just for benefit of Mr. Aikenhead, to have that supplied in writing just so that everyone can see it and go back and think about all these numbers. It's hard to do that in real time, but
sure.
One of the issues here, Mr. Tupler, for staff, recommends that P&M provide updates for purposes of RPS compliance in the dockets in which they are, well, maybe in this docket it was his recommendation. But I guess I'll put the question this way, Mr. Gutierrez. I mean, what you've just done, I think, is kind of what Mr. Tipler wants to happen. You know, and I think it's a reasonable request to say, hey, we need to be apprised as to, you know, where rec generation impacts. It sounds like you're capable of doing that rather readily. Is that right?
We can certainly do it. You know, just kind of taking a step back though, you know, if I look at it, my SG2, I'm showing that we're banking approximately 1.1 million recs for 2023.
Okay.
And so, you know, when I say I'm reducing that bank by 150,000, you know, it's really a minimal impact, I would say, to our rec position for 2023. So it certainly can be done. It's just unless something catastrophically happens to our entire system, our portfolio of renewables, I would expect us to certainly meet our compliance requirements for the plan year.
Sure. I mean, my only question would be, and as I was thinking of Mr. Tupler's suggestion, I mean, I think as I say, I think it's reasonable. My concern was that, you know, it's sort of compliance notice fatigue. There's so much. And I think it's a bad thing. I'm just saying that making sure that it's all happening in kind of one place. So, I mean, to the extent to which you were ordered to sort of do RPS updates within perhaps those other dockets, you're capable of doing that.
Yeah, I can surely make those updates. And I think, like Mr. Phillips alluded to, you know, things are changing quite a bit in, you know, this arena of delayed resources, supply chain issues. And so things change, have been changing quite a bit. And so the dynamics are constantly changing. And so it might be beneficial to do them less frequently, but I can certainly do the calculations.
I understand. And then I believe, and I'm trying to recall, Hearing Examiner Anaya Allen, I believe there was some line of inquiry that you had with Mr. Phillips, and he deferred to Mr. Gutierrez in the subject. And I'm just trying to remember what that was. Do you recall?
Yes, that had to do with the P&M proposal that it retire the customer, the small solar, and the 3 programs for solar recs, customer solar recs that were proposed by Ms. Sanchez's testimony. So that was, I believe, the CCPS program and the the customer solar rec purchase program, CSPP, and the capacity reservation program. So P&M has proposed that those programs be retired at the end of 2022. And so the question I had asked Mr. Phillips, and he deferred to you, looking at SG2 on lines 8 and 9, I believe, reference those 2 programs and the recs that are received as a result of those 2 programs. Is that correct, that those lines 8 and 9 reflect the CSPP and the capacity reservation programs?
Yeah, I would agree that we're accounting for any customer contracts that have been signed between 2020 and 2022. So any contracts that have been signed for those recs will be accounted for in my I'm calling them distributed generation recs. So those would be accounted for there.
Okay. And so the small PV recs, it says 0. Those are the recs under 10 kilowatt.
Actually, no. The recs would be from the CSPP would be a combination of line 12 and line 13. Line 8 is a is another program that has since been closed, and those contracts have actually rolled off of P&M's books, so we're not purchasing any RECs from any of those customers in that program.
Okay. So how would the termination of the program affect your calculations for 2023 and 2024?
If I just take the entire total distributed generation RECs, we're talking very minimal. If I look on page 1 of my SG2, the DG diversity for 2023, so you can see line 16, it's 2% of our portfolio, our total portfolio RECs, and that doesn't even account for the banked RECs. So it's a really small portion of how we would use RECs to meet our compliance.
So do you think then that this would not have an impact on PNM's ability to meet its requirements for 20% renewable generation?
If I didn't account for those RECs in 2023, it would not have an impact on us meeting our compliance.
Okay. And that includes both the CSPP and the capacity reservation?
That's correct.
So those are 12 and 13, not 8 and 9.
That's correct.
I'm sorry, 12 and 13, not
lines 8 and 9 on exhibit SG2.
Thank you.
Yeah, just to clarify, on line 12, a portion of the CSPP RECs would be in there, not all of them, but a portion would be, because I'm accounting for capacity reservations from 2018 through 2022 there. But just, I agree that, pulling those out of the portfolio, it's not going to affect our compliance.
Okay. So it would have some minimal effect on your banked RECs.
That's correct.
And then the other question I had, Mr. Gutierrez, has to do with related to hearing examiner Ryan's question on page 4 of your testimony, of your direct testimony.
Okay.
So I'm just, if you could just briefly describe for me what the voluntary programs are that are reducing the retail sales projection on line 12.
Yeah, and so I give a good explanation of those programs. If you go back a couple pages, starting on page 2, starting on line 19 of page 2, and it spans through page 3, line 3. I talk about the 3 voluntary customer programs there. One is Sky Blue. The other is customers that are taking service under rate 36B pursuant to the special service contract. And then the third program is Solar Direct.
Okay, so those are the same as the programs referenced on page 4?
Yes, ma'am.
Thank you very much. I don't have any further questions for Mr. Gutierrez.
Mr. Aiken had any redirect?
No, none from me. Thank you.
Any other questions from Mr. Borman? Anything?
Not from staff, no.
All right. Well, it appears we have no further questions for Mr. Gutierrez. Thank you very much for joining us today, sir.
You're welcome. Thank you, Mr. Commissioner.
Okay. It's a little afternoon. Why don't we break for an hour? Mr. Lee, we can go off the record. And it is 12:07. So let's come back at 1:10.
Sounds good. Thank you.
Thank you. Okay, it's 1:10. There's Mr. Lee. Let's see, we have everybody else. Ms. Nia Allen is there. Looks like everybody else is basically here. Okay, Mr. Lee, let's go back on the record. All right, we're returning from our lunch break in 22-00143. And we're picking up with PNM's presentation of evidence. And Ms. Kelly, you can call your next witness.
Thank you, Mr. Hearing Examiner. PNM calls its next witness, Mr. Tom Baker.
Mr. Lee, if you could swear the witness.
Please raise your right hand. You solemnly swear the testimony you're about to give in the matter of opinion should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Baker. Could you please state your full name for the record and your position at PNM?
Sure. My name is Thomas Baker. I am a manager of the cost of service department at PNM Services Company.
And did you pre-file testimony in this case?
I did. I filed my direct testimony on June 1st, 2022.
And do you have a copy of what has been marked as PNM Exhibit 9 in front of you?
I do.
And can you identify this?
Sure. That is my direct testimony filed in this case on June 1st, 2022.
Was this testimony prepared by you or at your direction?
It was.
Do you have any corrections to make to your direct testimony at this time?
No, I do not.
And if I were to ask you the same questions in your direct testimony today, would your answers be the same as they were when you answered them?
They would, with the caveat of the delays that to the San Juan replacement power resources that PNM witness Shane Gutierrez provided a little bit earlier in this hearing, which have a very immaterial impact on the total revenue requirement.
And is your direct testimony true and correct to the best of your knowledge?
Yes, it is.
PNM now moves for the admission of the exhibit of PNM Exhibit 9.
Any objection?
No.
PNM Exhibit 9 submitted.
And PNM has no further questions for Mr. Baker on direct at this time.
Terrific. Mr. Baker, what we're doing here is I'm going to ask you about your supplemental testimony. This has become, rather than PNM exhibits, commission exhibits. So you recall providing supplemental testimony in response to bench requests of August 23rd, 2022?
I do.
And you were the author of those responses?
Yes, I was.
And they're true and correct to the best of your knowledge?
Yes, sir.
And if asked those questions today, and you were to provide me the answers as we sit here now, would you answer in the same way?
Yes, I would.
Okay, with that, I will move for the admission of the supplemental testimony in response to bench request of August 23, 2022 by Thomas S. Baker, dated August 30th of 2022 as Commission Exhibit 4. Any objection to that? Nope. And that's admitted accordingly. Okay. Any questions for Mr. Baker from any of our interveners? It would seem not. Very good. So I'll just ask a few questions, Mr. Baker.
I would note, Mr. Hearing Examiner, staff does not have any questions either.
I'm sorry. My apologies, Mr. Borman.
No worries. I just wanted to make that clear on the record.
Yeah, and I lumped you in with the interveners. My bad. I may just have one question for Mr. Baker. You know, actually, I do not. I think I also have no questions for Mr. Baker. Miss Anaya Allen, do you have any questions for Mr. Baker? Sorry, so hearing examiner Anaya Allen, did you have any questions for Mr. Baker?
No, I do not.
Okay, good. Well, Mr. Baker, that was very quick. Thank you for joining us for only a brief period of time.
Thanks for having me.
Yep.
PNM is going to call its next witness, which is Heidi Pitts.
Okay, and she's there. Mr. Lee will swear her in.
Would you please raise your right hand? Oh, she's not there.
Nah, I think we're waiting on her for switching over.
She'll just switch the rooms with Mr. Baker. Sorry, 1 minute.
No problem.
Mr. Aikenhead, are you examining this witness?
Yes, sir, I am.
Thank you, ma'am. Go ahead. Ma'am, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
All right, thank you. Good afternoon. Would you please state your full name for the record and explain what your position is with PNM?
My name is Heidi Pitts, and I'm a lead pricing analyst with PNM.
Thank you. And did you prepare pre-filed testimony in this case?
Yes, I did.
Would you please, or do you have available to you what's been pre-filed and marked as PNM Exhibit 11?
I do.
And was that testimony prepared by you or at your direction?
Yes, it was.
Are there any errors that require correction in that testimony?
No.
If I ask you the same questions today that are set forth in PNM Exhibit 11, would your answers be the same?
Yes, they would.
Very good, thank you. And is your testimony true and accurate to the best of your knowledge?
Yes, it is.
Thank you. I'll go ahead and move the admission of what's been pre-marked as PNM Exhibit 11.
Any objections? And Exhibit 11 will be admitted. I assume you'll pass it to me, Mr. Aikenhead.
I will pass, yes. Thank you,
Thank you.
Mr. Zimmer.
No problem. So Dr. Pitts, I'm going to ask you some just foundational questions about your supplemental testimony. I issued some bench requests on August 23rd, 2022. And then on August 30th, 2022, you supplied a document entitled Supplemental Testimony in response to the bench requests on that date, August 23, 22, of Heidi M. Pitts, and you're the author of this document?
Yes, I am.
And your answers in this document are true and correct to the best of your knowledge?
Yes.
And if I ask you these questions today, you would respond to them in the same way that you do in the writing, as you would respond in the way now as you did in the writing?
Yes.
Great. And are there any corrections?
No, there aren't.
Wonderful. So I will move for the admission of Dr. Pitt's supplemental testimony as Commission Exhibit number 5. Any objections? Hearing none, that document is admitted into the record as well. Questions for Dr. Pitts from interveners and or staff?
Someday we'll have questions for Dr. Pitts, but today is not that day.
Nobody else? Okay. I know hearing examiner Anaya Allen and I have questions for Dr. Pitts, nothing extensive, but just so Dr. Pitts, I've read the answer to the question, and this is going back to the supplemental testimony, explaining why there's an increase in the average customer bill, but a seeming decrease in the revenue requirement. And I've read your response, and I've looked at the chart at the top of page 3. And I guess I'm just hoping you could use some additional words to make sure I understand this. So could you just try explain it to me in whatever way you think it'll get through to me?
Sure. So the revenue requirement that was filed and approved last June, or was filed last June in the case that was then trued up in February, it was about 66 million last year. And then it was trued up in the February filing, looking at the actual performance of the PPAs, the energy produced and things throughout 2021, as well as any change in cost of debt. So those are normal reconciliation items when you look back at compare the forecast and make it updated for the actual performance. But then there was also an overcollection of monies through the Rider 36 in 2021. And so both of those things come together when the true up is filed in February to calculate the new rate. And so that reduced the last year's revenue requirement by about 11 million, but about half of that was because of the overcollection. So then if you're just comparing same thing to same thing, the revenue requirement for the resources, the PPAs, the solar facilities and things, you wouldn't take into account the overcollection monies. And so if we don't look at the overcollection monies, just from a revenue requirement comparison standpoint, then the true up revenue requirement was a 61 million, 61.2 million. And so then the revenue requirement that Mr. Baker filed with this case decreased slightly, looking at the forecast performance of the PPAs and the revenue requirement for the solar facilities. So it decreased a little bit. But when we calculate the rate that customers pay, of course, we have to take into account the overcollection of monies from last year. So the rate that is in effect right now that we recalculated in February did take into account that extra 6 million that had been overcollected from last year. And so it was calculated on a $55 million revenue requirement. But Mr. Baker is comparing just the revenue requirement without the overcollection to this year's revenue requirement. And so it doesn't have, that's where the revenue requirement looks like it's decreasing slightly, but the rate that we calculate that people pay was based on 55 million, not 61 million in February. And so now it's going up because the revenue requirement that I use to calculate the rate this year is 61 million, 61.0 million.
Okay. And then the over collection, where does that get returned to the customer to the extent to which it does?
Well, they already paid it, so they're not paying it now because the rate was reduced. The rate last year was calculated based on forecast sales and things, and then it's trued up based on actual sales, the actual production of the facilities. So they've basically already paid that much last year. And so we wouldn't double collect it this year. So it's excluded from the rate calculation.
Okay. I think I just need to think about that for a little bit, but hearing examiner Naya Allen, do you have any follow-up questions about that subject?
Yes, thank you. So do you know, Ms. Pitts, what the rate was in 2021 that resulted in the overcollection?
Let's see. Off the top of my head, I don't know exactly. I believe right now it's 0.006 and 4 more decimals. So by decreasing the revenue requirement about 11 million, 0.008 something or 0.007, but higher than 0.006.
So
I would have to go back and check.
So regardless of what the number is, there was a reduction of the rate as a result of the true up in February 22?
The revenue requirement was updated for the performance in 2021. And so then we recalculate the rate and we reset it starting May 1st.
And that's the 0.006.
That's in effect right
number.
now, correct?
So that went into effect May 1st of 2022.
Yes, and the rate that I calculate for next year's plan, we propose would go into effect on January 1st, 2023.
So given the over collection in 2021, why would this increased rate proposal not result in an over collection for 2023?
It might, because these are based on forecasts, like forecast energy sales and the revenue requirements based on the forecast performance of the PPAs and the things that comprise the revenue requirement. So it might result in an overcollection, but at which point the carrying charge is applied to the overcollection, and then the whole amount would be deducted from the trued up revenue requirement for this calendar year, because we will file every February, we file an update to the Rider 36 renewable energy rider to update the rate and the revenue requirement. So that's an annual process that we go through. So at that point, any over or under collection is added to the revenue requirement.
So when the calculations were made that resulted in the proposed rate increase to 0.007, et cetera, what consideration was taken of those items that resulted in the over collection for 2021?
I'm sorry, Madam Hearing Examiner, I'm not sure I understand what you mean by considering those items. Could
So,
you restate your question?
Sure. So for 2021, the rate that was approved resulted in a pretty significant over collection or surplus of monies received from customers, correct?
Yes.
Okay. And so that was based on projections then that turned out to not be entirely consistent with actual, inputs into the financial process, I guess you could say. So the number, the rate that was approved for 2021 resulted in an over collection.
Yes, some years it results in an under collection.
Okay. So why do you think that there won't be an over collection if we approve this proposed rate increase to the 0.007 number?
Well, I don't really. I mean, it would be extraordinary if it didn't result in either an over collection or under collection, just given that it's based on a forecast, and also it's based on forecast, it's $1 per kilowatt hour rate. And so if we sell more energy or less energy than forecast, then that $1 per kilowatt hour charge, the rider charge, is collected on more kilowatt hour sales or less kilowatt hour sales. So that's one thing that can affect it. Maybe it's a cooler or hotter year than the forecast would suggest, and so that impacts it. And then, of course, the other things that impact the revenue requirement, like from last year, the 2 PPAs underperformed in terms of the energy that was generated. So I don't have an expectation one way or the other as to whether it would be an over or under collection, but it's highly likely it will be one or the other, that it won't be spot on. And that's why, regardless of whether it's an over or under collection, it's treated the same way. A carrying charge is applied to that amount, and then it's added or subtracted to the trued up revenue requirement when Mr. Baker is able to look back at the actual performance for the entire past calendar year.
So when you made the calculations that have resulted in this request for an increase for 2023, did you look at what the changes were that resulted in the overcollection in 2021? I.e., did you learn from whatever, not mistakes, but assumptions were made in 2021 that turned out not to be accurate?
It's not, pardon, go ahead.
Oh, and did you apply that information that you learned from the changes for 2021 to what you're projecting for 2023?
Well, it's not a matter of making a mistake. It's merely a forecast of how much energy will be used, a forecast of how much energy will be produced by these resources. And so just natural forces of events impact every stage of that. And so it's not a matter of forecasting the weather better or usage better. That's outside of really what I do as a pricing analyst. So no, it's not a matter of learning from that. We take the revenue requirement and then the forecast energy sales for the year, and then from that calculate a rate, the per kilowatt hour rate.
I mean, do you know what the differences were that resulted in the overcollection for 2021?
In terms of whether we sold more energy than was forecast or?
Right.
No, I do not.
And who would know that, do you know?
Gosh. I don't know. I don't know, Madam Hearing Examiner, I'm not sure.
Thank you. I don't have any further questions for Ms. Pitt, for Dr. Pitts.
Mr. Aikenhead, anything you redirect?
No, Mr. Hearing Examiner, thank you.
Dr. Pitts, and I assume no one else is chiming in, so I can excuse Ms. Pitts. Dr. Pitts? Yes. Thank you, Dr. Pitts.
Thank you.
Okay, P&M, that's the end of your presentation, yeah?
Yes, that is correct.
Ms. Gould, are we going to go to Mr. Meyer, I presume?
Yes, if that's okay with.
Yep.
You all.
So Mr. Lee, yeah, sorry, thank you.
Hand, please. You solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon. My name is Kelly Gould. I represent New Mexico Affordable Reliable Energy Alliance, also known as NM Area. Can you please introduce yourself and spell your name for the record?
Sure. My name is Greg Meyer, M-E-Y-E-R, and I'm a.
And who?
Go ahead.
Who are you employed by?
I work for Brubaker and Associates, Inc., out of St. Louis, Missouri.
And what's your job title?
I'm a principal with the organization.
Who are you providing testimony for today?
Providing testimony on behalf of NM area.
You have in front of you what has been marked as NM Area Exhibit 1, which is titled The Direct Testimony of Greg R. Meyer, filed on behalf of New Mexico Affordable Reliable Energy Alliance, filed on August 12th, 2020. Is that correct?
2022, yes.
Sorry, 2022. Thank you. Is this an accurate copy of your direct testimony filed in this case?
Yes,
Was this document prepared by you or under your supervision?
it was.
If the same questions were asked of you today, would your answers be the same?
They would.
And these answers are true and correct to the best of your knowledge?
They are.
I ask the hearing examiners to move into evidence NM Area Exhibit 1.
Any objections? NM Area Exhibit 1 is admitted.
And do you have in front of you what has been marked as NM Area Exhibit 2, titled NM Area's Response to the Hearing Examiner's August 23rd bench requests?
I do.
Is this an accurate copy of the bench request answers filed in this case?
They are.
Was this document prepared by you or under your supervision?
It was.
And if the same questions were asked of you today, would your answers be the same?
They would.
And these answers are true and correct to the best of your knowledge?
They are.
I ask the hearing examiners to move into evidence NM Area Exhibit 2.
So just one follow-up question, Mr. Meyer. Some of the responses in the supplemental testimony you provided sort of speak in the third person. You know, like for instance, request number 1. Then there's the question, and then it says, "No, Mr. Meyer is not asking P&M to recalculate its RPS revenue." Just to be clear, so even though that's written as if it's talking about you, it is fair to infer that you're the speaker of these things and mean to convey whatever information is included in these responses.
That's correct.
Okay. Well, is there any objections to the admission of New Mexico Area Exhibit number 2? Hearing none, New Mexico Area Exhibit 2 is also admitted.
And I would just ask the hearing examiners, my internet has been a little on and off this afternoon. I've done everything I can on my end to shore it up, but if I drop off while questions are being asked of Mr. Meyer, could we pause until I could pop back on Zoom?
Sure. Let's see if folks have questions.
Okay, I pass the witness for cross-examination. Thank you.
Interveners or staff, questions for Mr. Meyer?
P&M goes.
Oh, excuse me. My apologies. Sorry, we fell into a habit there. Yes, P&M.
No questions, Mr. Hearing Examiner.
Thank you. And thank you, Mr. Borman. So now for interveners and staff.
Staff certainly has no questions for Mr. Myers.
Okay. And I believe, I can say I have no questions for Mr. Meyer. Hearing examiner Anaya Allen, do you have questions for Mr. Meyer?
No, I do not. Thank you.
Great. Mr. Meyer, thank you for joining us today.
Thank you.
Okay. We are, I think, staff, you have your witnesses.
Staff has two witnesses today, yes.
Yep.
Staff's first witness will be Bamadou Otara. And so I would ask him to be sworn.
Would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Utara.
Good afternoon, bro.
By whom are you employed and in what capacity?
I'm employed by the Public Regulation Commission as a public utilities economist for the utility division.
As part of your duties in that position, did you review the 2023 RPS plan submitted by P&M in this case, along with the testimony that they filed?
Yes, I did.
And based upon that review, did you prepare or participate in preparing testimony regarding that plan?
Yes.
Okay. You should have before you a document marked as Staff Exhibit 1. Do you have that document?
Yes, I do.
Can you identify that document?
That document is my direct testimony that was filed on August 12, 2022.
Okay. And was that document prepared by you or under your supervision?
Yes, it was prepared by me.
Okay. Do you have any changes or corrections to that testimony?
No, I don't.
If I asked you today the same questions as are set forth in Staff Exhibit 1, would your answers be the same?
Yes, they would.
Are those answers true and correct to the best of your knowledge?
Yes, to the best of my knowledge.
Okay. And do you adopt Staff Exhibit 1 as your sworn testimony in this matter?
Yes.
Thank you. At this time, I move admission of Staff Exhibit 1.
Any objections to the admission of this document? Hearing none, Staff Exhibit 1 is admitted.
Mr. Utara is available for cross-examination.
P&M or any of the interveners have any questions for Mr. Watara?
No questions from P&M.
It appears there's no questions from Mr. Watara from anyone. I have no questions from Mr. Watara. Hearing examiner Anaya Allen, do you have any questions of Mr. Watara?
If I could just have a moment.
Sure.
No, I do not have any questions. Thank you.
Mr. Watara, thank you very much for joining us today.
Thank you.
May all your testimonial experiences be as good as your first.
Thank you.
All right, Mr. Borman, on to Mr. Tupler.
Thank you. Staff now calls Mark Tupler.
Mr. Lee, if you, do we have Mr. Tupler there?
I'm here. Right hand, please. You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir.
Good afternoon, Mr. Tupler.
Yes, sir. Good afternoon.
By whom are you employed and in what capacity?
I am employed by the New Mexico Public Regulation Commission as a senior economist with the utility division.
As part of your duties in that position, did you review the 2023 RPS plan submitted by P&M along with the testimony they filed in this case?
Yes, I did.
And based upon that review, did you prepare or participate in preparing testimony regarding that plan?
I did.
Okay, you should have a document before you marked as Staff Exhibit 2. Do you have that document?
I do.
Can you identify that document?
Yes, it is the direct testimony of myself filed on August 12, 2022.
It was Staff Exhibit 2 prepared by you or under your supervision?
It was prepared by me.
Do you have any changes or corrections to Staff Exhibit 2?
None.
If I asked you today the same questions as are set forth in Staff Exhibit 2, would your answers be the same?
They would be the same.
Are those answers true and correct to the best of your knowledge?
Yes, they are.
Do you adopt Staff Exhibit 2 as your sworn testimony in this matter?
Yes, I do.
Thank you. At this time, I move admission of Staff Exhibit 2.
This is a question for staff. I see somehow the document Staff Exhibit 2 included like a comments section on the right-hand side that carried over onto the PDF.
I don't see that, but maybe.
So I'm in Dropbox right now.
Okay.
If you log in, like, so on the original submission, when it was pre-filed, it included like some gray.
Oh, I do see comments.
So my
Would you
question
like us to upload without comments?
Yeah, well, so I was going to offer you, if you'd like to, my suggestion is that you definitely would like to. I just don't think we should put comments like this into the record that the court reporter ultimately gets.
I agree, and that's obviously my error, and I did not see those when I was uploading this, so.
No, it's fine. This stuff happens. It's nothing to be worried about. I just wanted to make sure we correct that before it goes.
Why don't I, shortly after this hearing, I will upload a clean version that does not include the comments.
Yes, I think that'd be best, and then that will be the official document that gets included in the court reporter's record.
Thank you.
No problem. All right, so that's putting that aside, and then I'll make sure. And I'm trying to think, Mr. Borman, maybe what you can do is similar to that, just upload to eDocket, that new thing, so everyone can see it. Does that make sense?
Yeah, yeah.
And then if you supply me a copy as well, I can see that it gets to the court reporter and is included in the final transcript.
So I just want to understand now what you want me to do. Do you want me to upload one? Do you want me to send it to you and all the parties? How do you want me to handle it?
So yeah, at this point, Dropbox isn't so useful. I mean, that's really just a tool for exchanging.
Okay.
I think it's easiest if you just file it on eDocket, the corrected version. In the same way, it's like kind of like treating it like a bench request. You know what I'm saying? Because P&M's going to do that too.
So file it in eDocket and serve it on the parties and the hearing examiners.
Yeah, and then Mr. Lee will have it and they'll get into the record.
Excellent. I will do that.
Thank you. Okay, putting that aside, are there any objections to admission of Staff Exhibit 2? I don't hear any, so we will admit Staff Exhibit 2. P&M, do you have any questions for Mr. Tupler?
No, thank you, Mr. Hearing Examiner, none.
Interveners, any questions for Mr. Tupler?
No, sir.
Okay, I have just a few questions for Mr. Tupler. Mr. Tupler, as to your recommendation about tracking the RPS consequences of the delays with the projects. I mean, I understand your suggestion, and I share that concern. And I read Mr. Gosh, come up with his name. Mr. Phillips is writing about your request, really not so much to be like, oh, I don't want to do that, as to, we have several compliance dockets open, and it may be just yet another thing in another filing to have to produce, and that could get confusing and perhaps laborious. So I guess my simple question was, would staff be satisfied if the recommended decision in this case said, well, the commission should just, in the existing compliance documents, start requiring P&M to tell us more about the downstream consequences of delays for RPS purposes? Would that satisfy you?
Yeah, it would. That was what I was trying to capture with the recommendation that I made. Quarterly reporting was kind of the time frame that was just in my mind. However, if there's no updated information, even a quarterly report serves no valuable purpose. The reporting requirement, as you mentioned previously here, I think is adequate.
The existing compliance notices that P&M's doing with staff.
So I may not be familiar with all of the open dockets that have that reporting requirement. But if the commission's satisfied with it, then I would defer to that schedule.
Well, and I might actually be asking more a question for Mr. Borman to comment on, which I don't ask him now, but you know, I think so. Let me ask you this question, Mr. Tupler. Do you think there's adequate reporting at this time, specifically with regard to RPS questions? There is existing reporting that satisfies you. Is that what you're saying?
I'm comfortable with that.
What are the existing RPS reporting requirements?
Well, I know that there's a bi-weekly meeting for some of the updates of the outstanding resource dockets. I don't know any further, or I don't know what the other dockets consist of, but I presume that they would be comparable. There's not always a big change or any new information in the bi-weekly meetings. And if I'm not mistaken, I do believe that there are some filings that are done by the company ahead of those meetings. What I was trying to capture again was just any significant changes in, am I still here?
You are.
I'm hearing you.
My computer just blacked out somehow. But I'll just keep moving on. If you can hear me and see me.
No, we can see you fine and hear you fine. Did your screensaver come on maybe?
I don't think so. Nonetheless, the question was about the reporting requirements and the time frame. My quarterly recommendation was simply based on my experience, maybe in the financial industry, where quarterly updates are adequately enough to drive management, regulators, whoever might be interested in the reports. They're less burdensome than bi-weekly, and they produce better information, I believe, because, like I mentioned, if there's no change in the report, I don't necessarily need to see it. Did I answer it thoroughly?
Yeah, I think I understand. I mean, I think ultimately, you know, we'll get, I assume, some sort of briefs from everybody. And perhaps if you and council, I mean, I understand there are bi-weekly meetings. I've heard about them at the commission open meetings, and I understand there's quite a lot of discussion that's going on. So I think my sense of it was, I think it's appropriate to be concerned about what's the RPS consequences of delays. I actually don't really know what the full picture is that staff is getting from P&M because I'm not part of those meetings. And I think to the extent to which we can just avoid having yet another docket where there's reporting requirements, that's probably beneficial for everybody. Let's just keep it sort of concentrated. And then if you and, you know, council want to recommend something in briefing as to what your feeling is, that's where we can just leave this. So I'm just saying that more for the record than anything.
Yes.
Another subject, Mr. Tupler, and your direct testimony at page 7.
Oh, here we go.
Is your machine up and running again?
I'm back on here, so I don't know what happened, but I feel a whole lot better now.
Good. No, that's good. This is why you have to have a paper copy of everything.
Right.
I've had this experience.
Okay, I'm at page 7. Yes, sir.
I'm trying to understand, you know, there's even a comment and a response to a comment in the copy that I'm looking at, that the what you're saying between line 6 and 10. And I won't read it all so as to save Mr. Lee from having to retype that. Can you just kind of explain what it is you're suggesting there and how we end up with the 1.5% and what is this all?
Okay, yes, I see. So I take an analytics approach to my analysis of most numbers in these applications. So that's what this question was intended to kind of show, was what the RPS requirement consists of in 2023 versus the information for 2024. So I'm showing what that increase is there on a percentage basis more than anything, along with a percentage variance of the subtractor, I guess is what I'd call it, or part of the calculation for that requirement number. What I was trying to do there is just capture the percentage variance from year to year.
Okay. These projections show that PNM's RPS requirement for 2024 will be less than a 1.5% increase from 2023. So could you just say that in a different way? What does that mean?
So it's a very small, the RPS requirements for 2024 is a very small increase from the prior year.
Okay.
And maybe that's just a result of the mathematics behind it, but it's a small increase from the year we're looking at versus the year that we're anticipating.
Okay. I think I understand what you're saying now. Okay. Moving down to line 15 to 16 there, you're talking about the Palo Verde replacement resources, and you write at 15 to 16, approval of these replacement resources for PVNGS is still pending in case 21-215. What do you mean by that?
So I understand in that particular case, 21-215, there has been a recommended decision filed by the hearing examiner. There have also been, if I'm not mistaken, some exceptions maybe filed to that recommended decision, but I do not believe that a final decision has been made yet.
Yeah, no, and I'll just say for the record that it's not surprising that that's sort of confusing because it was a bifurcated case that was subsequently bifurcated further. So the procedure, just for the record of this case, is that those resources were approved, and the outstanding exceptions relate to sort of ancillary matters that would not in any way impact the approval of the resources. So I just wanted to clarify that in case anyone reads this in the future and is curious.
I see.
I don't fault you at all for not following that one, because part of the reason why I was opposed to further bifurcating it is producing confusion. So, how does staff go about verifying? I asked Mr. Gutierrez sort of it's kind of a basic question, like where does PNM get its projections from on, sales and load for any particular year? And, he said it's our loads and resources group. I'm not sure if that's the exact title, but in any case, he said there's an entity that exists. How does staff verify PNM's projections?
Well, a projection by definition, I believe, has some kind of variability built into it. So it's more of a trust and verify as best I can. So I'll read through the testimony. I'll understand the basis for the components of their revenue requirement, I guess is what that ultimately turns into, and check for reasonableness. So it's pulled out of company testimony. And again, tested for or evaluated based on a reasonableness factor, because it is a projection. It's as professional a guess as anybody else can maintain.
Yeah, and I appreciate the fact that projections are just that. I'm just wondering if, with retail sales, the follow-up questions I asked Mr. Gutierrez were, well, what does all of the electrification movement mean in terms of increased projections moving forward, and how is that going to bear on RPS standards, right? Because if you have this onslaught of electric vehicles
Yeah.
and P&M's capable of selling a whole lot more. Well, you have not only like the 25 number jumping rather considerably, but in theory you should have a lot more electricity just because of electrification, and then that's kind of, I was just sort of thinking most generally. So I'm just wondering if staff has ways of making inroads, having independent projections about future electricity sales.
Agreed. I understand that there might be some consultants involved in coming up with that number. I can't say that I've read any of the consultants' reports by any means, but I do believe they find their way into the company testimony.
Let me see. All right, that's all the questions I had for you, Mr. Tupler. Hearing examiner Anaya Allen, would you like to ask Mr. Tupler any questions?
I do have one question. Well, I do have at least one question, Mr. Tupler. Did you review the recommendation by PNM that it terminate its REC program for individual solar customers that was proposed by Andrea Sanchez or discussed by Andrea Sanchez in her direct testimony?
Yes, I did.
And did you have any recommendation with respect to that proposal by PNM on whether or not to continue or terminate those programs?
Well, I don't have the subject testimony in front of me now at the moment. However, when I was reading through it, I understood the basis for it. It was reasonable. And reading through it, I agreed with the company. So I'm using their knowledge of the program and the metrics that are used to measure it to determine my position on that particular issue.
Did you happen to notice that they only base their recommendation on the cost to consumers for the small solar programs, the 0 to 10 kilowatt? They didn't provide any economic analysis on the larger programs?
I don't know. I don't believe that I noticed that at the time. By you mentioning it now, though, I think I do recall that. I'm not certain what the participation level is at that next level, which in my mind might have some impact on why it was excluded. I can't recall it right this moment, but that would have been my thinking as I read through the testimony.
Thank you, Mr. Tupler.
Thank you.
I don't have any further questions from Mr. Tupler.
PNM, any questions for Mr. Tupler?
No, thank you.
Interveners, anything for Mr. Tupler? Mr. Borman, any redirect for Mr. Tupler?
Yeah, I do real briefly based on the questions that you asked him. Mr. Tupler, you got some questions from the hearing examiner about, you know, the reporting requirements that PNM currently has regarding resource adequacy and the recommended updates that you had put in your testimony. Do you recall that?
Yes, sir.
Okay. Now, the reporting requirements that are currently in place for PNM on resource adequacy, those aren't asking for the same information as as what you recommended in your testimony. Is that correct?
I would say that's correct.
Okay. Thank you. No further questions.
Okay. I mean, just to follow up on that, Mr. Borman, I understand that. I think it's important that the commission have some forewarning of what's coming in 25 on RPS stuff. And I think Mr. Tupler's recommendation there is well founded. I mean, I understand it entirely. It's difficult to argue with it. It's totally logical. So, but the question I guess I had ultimately was, is it better to just embed it in the existing compliance documents, or do we need something independent? And that's not so much a fact question, I guess, it's just a judgment from staff. So maybe in briefing or whatever, you can comment on that. That seems reasonable, right?
That's what we would anticipate doing.
Terrific. Okay. I believe that concludes the evidentiary portion of the hearing. Anything need to be said about that? I don't believe so. So if you recall, the notice that I circulated in June 15th of this year, June 15, 2022, basically sketched out all of the remaining dates. And I did that very purposefully because last time we ran into a crunch situation. I've been through this, before. And in our pre-hearing, we had this discussion, when Thanksgiving comes and given the statutory deadline, you really are stuck with certain dates. So at present, this is going off of what was already circulated to the party. The transcript should be available. This is going to be an expedited transcript. Mr. Lee, I assume that can get provided by the 14th of September. Is that reasonable?
Yes, sir.
Terrific. Then if that happens, then we would have initial briefs on September of 23 or September 23 of 22. The response briefs would be September 28th. The recommended decision in this case would be circulated by the 21st of October. And due to my errant emailing, you already know that Ms. Anaya Allen will be largely leading the charge on that. I can issue this as an order, just updating and giving everybody these dates again. And then we have initial exceptions October 28th, and then response to exceptions November 4th. And that sets it all up for commission action on November 16th. And that'd be the latest you could do it, because the next Wednesday, the open meeting will be canceled as a consequence of Thanksgiving, which is the typical practice of the commission. So that's how she has to go. So I will, hearing examiner Anaya Allen and I will sit down and map this all out for you all again, so you have it in writing and make it easy. Anything else before we go off the record?
No, sir.
No, thank you.
Okay, Mr. Lee, your job is complete. Thank you, sir.
Thank you, ladies and gentlemen. Have a nice day.
Great.
You.
Okay, everybody. Thank you for the hearing. Appreciate everybody participating.
Thank
and
you.
Till next time.